set for sentencing. Ms. Jeffers is present, represented by Attorney Dallas L. Rooney. People are represented by Prosecuting Attorney Timothy J. Rukowski. On April 28th of this year, the defendant has pled to identity theft. Ms. Mandy Alexanders prepared the pre-sentence report dated May 27th, 2025. Mr. Rooney, have you and your client had the opportunity to review the pre-sentence report?
We have.
Are there any additions, deletions, corrections, or objections to the report other than guidelines?
No to that and no to guidelines.
All right. Ms. Jeffers, do you agree with that? Thank you. Mr. Rukowski, any objection to the report as well as guidelines?
No, I had a question.
Thank you. Mr. Rooney, anything you'd like to say you had your client before the court imposes sentence?
Yes, Your Honor. My client is 25 years old. There's no criminal history of any kind before this incident. She's gainfully employed. She's highly educated and a master's degree in social work. She is actively engaged in therapy for herself. I think you're aware of the background divorce action between herself and the victim in this case. She does take responsibility for and regrets her decision and action regarding the ex's credit card, the vet bills that she got paid as a use of that card. I have gone over the recommendations with her. We had almost no objections to the proposed conditions. That's to implement the late sentence program. Two minor issues, the restitution request. I think technically there has not been one. If there is one, then she definitely will pay the $1,500 change. But I believe that the credit card company has written that off if the victim does not have to pay that. But if the credit card company or someone else or whoever comes forward. Another issue is the 3 days in jail, part of the agreement. She will make arrangements to report to jail sometime during the delay. It won't be this week because I believe there's a closing on the house set. So I don't know if you want to actually set a date or just have her.
I'm assuming the jail's going to prefer that. And deputy's nodding, so. Okay. Anything else? No. Ms. Jeffers, is there anything you can say?
I'm really sorry for how it has affected them, regardless of everything else that supported fair.
Ms. Jeffers, you come from a good family. Why? You know better than this. I mean, you sat there in the civil proceedings, looking straight in the eye, and then come to find out this is what it's all about. Oh. I'm not doubting that, but you have a master's degree. You're highly articulate. You speak very well, and you took from someone that you shouldn't have taken.
It was a bad situation. It was a shared dog, and so it was a back and forth. How to help, who to help. They were going to, if we weren't, I shouldn't, and I just made a bad call.
But when police contacted you, you lied to them.
Technically, he came over and gave me. Yeah.
You did. Rukowski, anything on behalf of the people? This is a victim's rights case.
The victim is here, wishes to address the court.
So, sir, would you please state your first name as well?
Calvin.
Mr. Kuhn, you may proceed. What would you like to tell the court?
Well, I'd like to first thank you, Your Honor, for giving me the opportunity to speak today. I'm here because I'm the victim of identity theft. That is a violation that has caused a significant financial, emotional, and personal hardship in my life. Since discovering this crime, I've spent countless hours trying to untangle the damage caused. I've had to repeatedly contact the debt collection agency, the credit card company, and even the veterinarian's office where the crime was committed, none of which I had any legitimate ties to. just to understand how my name and personal information had been misused. Each call was emotionally draining and time consuming and often led to more questions than answers. In order to defend myself, I had to take time off of work to gather and submit documentation proving that I was not responsible for these fraudulent activities. Missing work created an additional financial strain and an added stress during an already overwhelming time. One of the most devastating consequences has been the damage to my credit. Because of the fraudulent accounts and transactions committed in my name, my credit report is now severely impacted. As a result, I am currently unable to make any major purchases that require a loan, including necessities like a car or housing, because lenders see me as a financial risk for something I did not do. This crime has robbed me of more than just my time and my money. It has stolen my peace of mind. I now approach everyday financial decisions with fear and hesitation. I constantly monitor my accounts, question the safety of my personal information, and worry about long-term consequences that I am still uncovering. Your Honor, I want to emphasize that identity theft is not a minor inconvenience. It is a deeply invasive and traumatic experience that affects victims long after the initial crime. I respectfully ask that the court recognize the severity of what has been done, not only to my finances, but to my life, and hold the responsible party fully accountable for the harm they caused. And to the individual who did this, I sincerely hope you take this opportunity to seek the mental health help you may need. What you've done has had real and lasting consequences on my life, and I urge you to reflect on your actions and find the support necessary to prevent causing this kind of harm to anyone else in the future. Thank you.
Thank you. Mr. Kowski, you have any?
Well, Your Honor, that's been my conversation with Mr. Kuhn through this entire process. The fact that you have a marriage, the marriage goes in a different direction, and yet that personal identifying information that the defendant had from Mr. Kuhn that she used to open up this account. And I think it gets underscored by the fact that his credit has been affected. I mean, that's really what most of us, we try to make any kind of purchases and that, everybody's gonna look at your credit. And because of this, which he had no fault in whatsoever, it affects him. As my understanding for restitution, he's been covered for purposes of the vet bill, but the credit card company is out. I have no idea if they're submitting something or not. We'd ask that keep the restitution issue open, Your Honor. But as it relates to the underlying crime, I mean, it's very significant to have your credit affected, and that's what happened here. And as the court pointed out, when Ms. Jeffers was approached by the police, it was one story, then another story, and then finally, when they got her IP address, it's like, well, he was with me, and I mean, that is the concern. We engaged in a plea offer with Mr. Rooney. We believe that it's fair and appropriate under the circumstances. We talked to Mr. Kuhn about it before we entered into that plea agreement. But we wish the court to underscore that with the defendant here about where she's at and what needs to be taken care of. As far as the jail time, just so that the jail is aware of it, this is not the court sentencing Ms. Jeffers to jail because the delay of sentence. The court can't. This is a revocation of bond, so there is no jail credit. Sometimes they'll say, well, we give a credit. Well, you don't get credit for this. This is a revocation of your bond for 3 days. It's an agreement between the defense and the prosecution. So she has to serve those 3 days. When that will be, it has to be during the delay period. So whatever that is, she has a year to make sure that she gives the 3 days to the jail. Court, have any questions of me?
I don't. Thank you.
Thank you, Your Honor.
Well, thank you. Clearly, that's the nail. He hit it right on the head. And Mr. Kuhn's statements as well. Knock on wood, personally speaking, I've not had my credit rating attacked, but I've had clients over the years that have when I was in private practice, and it is the most unnerving, just rattling experience for anyone. And it's something that no one wants to do. Ms. Jeffers, the plea offer, it would appear to me, was extended to you based upon the fact that not only are you young, very young, but no prior record to speak of, highly educated, gainfully employed, but really just did a boneheaded move here.
June 29th, 2026.
June 29, 2026 at 9 a.m.
Yes.
for review. The ultimate goal here is we see you on that day and no issues, the delay of sentence would enter and the lower conviction would enter. If you come back before the court earlier, it'd be a different time. Go ahead.
Do I have to complete a mental health assessment if I've been in therapy for years. I've given assessment done every year annually.
I ordered it, we'll leave it at the discretion of the agent. If you can provide information to the agent that satisfies that component and they are satisfied, the court will be satisfied as well, but I do have that. Okay, good luck to you.
Thank you.
Thank you, Mr. Ray. Off the record.
Okay, this is 250437 FD, the People versus Harry Strange.
Judge, good morning to you and staff in Haitian with and on behalf of Mr. Strange, who's present to my left.
It's nice to see you in person.
Likewise, Judge.
Okay, so it's a time and date set for preliminary examination. How are we proceeding today?
Judge, that is correct. I've had a chance to go through the materials with Mr. Strange. We've discussed this matter extensively with the prosecutor's office, including going through potential deviation in the district court level. Given where we're at right now, my client is going to waive his right to an examination, understanding the probable cause standard there. He knows he'll be bound over to the circuit court.
Okay, can I go on to your client briefly? Sir, you understand under Michigan law, you have a right to a preliminary exam. And you understand at that exam, the prosecutor must show that a crime was committed and probable cause exists to charge you with that crime. And are you voluntarily waiving that right after speaking with your attorney? Okay, and you understand that you'll be bound over to the circuit court on the charges as they're written in the complaint and warrant?
Yes.
Okay, and did you have a chance to go over the charges against you with your attorney?
Yes.
Okay. All right, I find that the waiver preliminary exam is knowing and voluntarily given. Sir, you'll be bound over to the Third Circuit Court for future proceedings. Your arraignment on the information date is August 4th of 2025.
Excellent.
Okay,
Noted, Your Honor.
and I also just note for the record that the prosecutor had no objections to the waiver.
Wonderful. Thank you, Your Honor.
All right, we're all set. Thank you. Have a good day.
You too. Good day, folks.
McMahon, are we ready on that or?
He's out here and see, if you talk to him, did he leave the file?
No, he had Oh, okay, we're waiting. All right, this is 251159 FD, the People versus Miguel Monte Aaron.
Good morning, Your Honor. James Gazicki on behalf of Mr. Aaron, waive reading of the complaint, stand mute. Request a personal bond. Mr. Aaron reports that he's been in jail since the 4th of May on a violation of probation because of this charge. He indicates he notified the prosecutor's office to bring this matter up, but he never did. And the reason why he didn't show up when he was supposed to, Your Honor, he changed addresses and apparently didn't notify anybody. So we're asking for a personal bond in this, Your Honor.
Okay. Sir, can you tell me your first and last name?
Yes, Your Honor. My name is Miguel Monte Aaron II, Your Honor.
All right. Sir, I have to tell you a few things. You have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have the right to an attorney, and you have a right to have that attorney present during any future questioning or any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you, as Mr. Kaczynski was appointed to represent you today. And I've signed the request for a court-appointed attorney to ensure you have counsel present at your next court hearing. You have 2 dates within the next 21 days. The first is your probable cause conference, and that will be next Monday, July 7th in the morning. We'll get you the time and we'll make sure that your facility is aware if you're still on hold there. If not, you know, if you're released, you understand you have to be here. You can appear at that hearing via Zoom next Monday. Following
Yes.
that, okay, good. Following that, you'll have your preliminary exam. It's tentatively set for July 14th of 2025, and you can appear at that hearing in person. You must appear, and that will be your preliminary exam where the prosecutor will show the crime was committed and probable cause exists to charge you with that crime. Sir, I am going to give you a personal bond of $2,500. These are your bond conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot consume alcohol or illegal drugs. You will be subject to random testing at your expense. You cannot operate a motor vehicle without a valid license. And I don't know if you were printed on this offense or not, but you're to be printed upon release if that hadn't occurred. Understood?
Yes, Your Honor.
All right, anything else? All right, we'll see you next Monday, sir. You're all set.
Thank you, Your Honor.
Thank you. All right, McMahon. Oh. Good morning.
Good morning, Your Honor.
All right, we have 2 cases here on Mr. McMahon. Are these both Taylor cases? They are. Okay. So we have, let's do the 251524. We're also on record on 243385. The People versus Luke Ryan McMahon counsel.
Joshua Kevin on behalf of Mr. McMahon, let's do
Luke Ryan McMahon.
Okay, so we have 2 cases here. The first one is Mr. Keys, you want to give me your appearance?
Yes, Matt Keys on behalf of Probation.
All right, thank you. So the first one is this OWI case, and I have a plea form in front of me that it would be amended. It's an OWI, it would be amended down to an operating while visibly impaired with the condition that Mr. McMahon complete our treatment court program. For Michigan State Police as well. The letter from the Attorney General. Is there anything you want to say on behalf of your client?
Yes, thank you, Judge. This is a conviction from 20 plus years ago. Mr. Andrews is not the same person. However, the conviction on his record is still holding him back, and he'd like to have it removed and others so that he can continue or at least attempt to be a productive citizen. He's presently doing gig work, but he'd like to be able to apply for something a bit more stable, and his record presently doesn't allow for him to be able to do that. Having this conviction and others on his record has taught him to remove himself from negative people, and that ultimately he is solely responsible for his actions. Mr. Andrews has lived and learned and is much wiser considering the age of the case. He's a much different person now than he was back at that age. He's also had other expungements, so for these reasons, we're asking for a set aside today, Your Honor.
Okay, he meets the statutory requirements. So and I should just note for the record, there's the prosecutor has no objection to the set aside, and they've not been able to contact the complaining witness due to the age of the case. So you'll have to submit an order, and I'll grant the set aside.
All right, will do. Thank you.
All right, we're all set.
Have a good day.
Thank you. You too. Thank you.
Although I think I see you on Thursday, I think.
Yep, I'll be here. I'll see you then.
All right, you can log off, Mr. Andrews.
Mr. Andrews, you're all set.
Thank you.
All right. So I have the Quanta Green. I know I had this file up here, but I'm not sure. Okay. And I have Mr. Winford's file too. We're waiting for Mr. Gazicki on this. Oh, yeah. Oh.
For the exam.
What's that?
Might draft out for the exam.
And when she's ready, have you talked to her?
I checked in with her as soon as I got in today.
Okay, yeah, she might just not know that they're ready. All right, Detective Collip.
Good morning, Your Honor.
Hi, good morning. I'm sorry, I didn't see you there. This is
No,
your
that's all
case number. Your case number is A2TA/2518657, the state of Michigan versus Jonathan James Woodard. Can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your name for the record?
Detective Philip Collip.
Have you read the type complaint that was filed with the court?
I have.
Are the facts stated in the complaint true to the best of your knowledge and belief?
Yes.
Can you state the facts that support the issuance of the arrest warrant?
Yes. On 6/25 of this year, at approximately 16:29 hours, Detective Giacomo was working in an undercover capacity, posing as a juvenile female on an open source social media platform. During this time, Detective Giacomo was on the Meet Me app. While on the Meet Me app, he received a message stating hello from a male, later identified as Jonathan Woodard. The conversation on Meet Me continued. Detective Giacomo and Woodward and eventually switched to text messaging. On 6/26, while texting, Woodard, Detective Giacomo explained he wasn't 18 and that he was actually 15, about to be 16. Jonathan texted, or Woodard texted, "What are you doing trying to get me arrested?" Woodard also texted, "I don't think it's a good idea for us to meet up. If you're 18, it's a different story." Later in the day at about 11:04, Woodard texted Giacomo back, "When do you turn 16? Detective Giacomo told him December. Woodard then texted, "Can you go to the library by the park today?" referring to the library at Heritage Park. Detective Giacomo texted back, "I thought you didn't want to see me." He replied, "Don't be mean, we can meet." Woodard and Detective Giacomo exchanged several more text messages. Woodard texted, "You should, CUM, come now." And Detective Giacomo replied, "CUM or COME?" And Woodard replied, "Both." Detective Giacomo texted, "How would I do that?" Woodard replied, "Come here and see." The Giacomo then texted, "I'm down, just not trying to catch a disease." Woodard replied, "I am very clean." The Giacomo then texted Woodard, what are we going to do? Because I don't want to get pregnant." Woodard replied, you won't. I have had a vasectomy." Detective Giacomo then texted, "So I won't have babies." Woodard replied, "That's right." DeGiacomo then advised Woodard he was almost to the library. Detective Oliver then observed Woodard leaving near the parking lot near the library. He was then subsequently stopped in a traffic stop by Patrolman Borg, arrested, and then transported to the Daily Police Department.
You signed the complaint before you sent it over to the court.
I did.
All right, let the record indicate I find probable cause to believe the accused committed the alleged offense and will therefore issue a warrant. Position on bond.
Obviously, the nature of the offense, I feel that he's a pretty big predator. I would ask a high cash bond and at least a GPS tether if he was to get out.
All right. Thank you, officer.
I think I have one more.
Oh, my goodness. Okay.
Yeah, there's a lot.
And this, yeah, this is A2TA/2518643, the state of Michigan versus Kenneth Kevin LeBron Hyde. Again, detective, can you raise your right hand? Solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Can you state your name again for the record?
Detective Philip Cowell.
Did you read the type complaint that was filed with the court?
I did.
Are the facts stated in the complaint true to the best of your knowledge and belief?
Yes.
You state the facts that support the issuance of the arrest warrant.
Yep. On 6/26 of this year, Taylor officers were dispatched to 9715 Cornell for felonious assault. The victim, Crystal Reed, was waiting for officers in her vehicle in the area. Upon arrival, she told officers that defendant Kenneth Hyde, whom she has a 5-year-old child in common with, Kennedy Hyde, pulled a rifle and pointed at her and Kennedy. She stated she was dropping off their child in common at 9715 Cornell when an argument started. Kenneth began making threats about Reed's new boyfriend. He then picked up a black rifle and pointed at her and Kennedy. She grabbed the barrel and pushed it away. Kenneth then removed a circular magazine from the rifle and set the rifle down. She stated he then picked up a handgun and began to manipulate the flashlight on it, which caused her to have fear and was unsure what he was going to do with it. She then fled the location with Kennedy. Officers made the location and took Kenneth into custody. A rifle, a drum rifle magazine, and a handgun were all recovered.
Okay. Did you sign the complaint before you sent it over to the court?
Yes.
All right, let the record indicate I find probable cause to believe the accused committed the alleged offense and will therefore issue a warrant. Also in custody?
Yes.
Okay. Anything on bond?
Just a high cash bond or whatever the court recommends.
Okay, all right, thank you, officer.
Thank you, Your Honor.
We're all set. Do I have Mr. Zicki? What did Ms. Soap say? Is she ready? Mr. Rayford, I'll be with you as soon as the attorney comes back in the courtroom, okay? I'm just waiting on your counsel.
Okay.
Oh, I'm sorry, Mrs. Rayford. I didn't see the A on the end of your name.
It's okay.
Interview with him down there.
Okay. All right, Detective Hinojosa, you're not muted. Are you ready for this swearing? All right. Hello. This is case number 82TA25-13601, the state of Michigan versus Carlos Javier Garcia Vega. Can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your name for the record?
Detective Mario Hinojosa?
Okay. Have you read the type complaint that was filed with the court?
Yes.
Are the facts stated in the complaint true to the best of your knowledge and belief?
Yes.
Can you state the facts that support the issuance of the arrest warrant?
Yes. On May 4th, 2025, I, Detective Hinojosa, was working in an undercover capacity, posing as a juvenile female on open source social media platforms. During this time, Detective Hinojosa was on the Scout app using the undercover profile. While on the Scout app, I received a message stating hello from a male later identified as Carlos Javier Garcia Vega. The conversation on Scout continued between myself and Vega and switched to texting. On May 7th, 2025, while texting, Detective Hinojosa told Vega that I wasn't 18 and was actually 15. Vega then replied, when my birthday was. I said October 19th. Vega texted, well, we can hang out and see how it goes. Myself and Vega continued texting, and Vega texted, when are we going to the park? And continued texting back and forth. On May 9th, Vega texted he wanted to speak on the phone with Detective Hinojosa. Officer Ruby Scott called Vega at 5:39, portraying the juvenile as the undercover profile, and they had an approximate 5-minute phone conversation with Vega where they spoke about arranging a time and place to meet up. Vega told Officer Scott to wear something cute. The phone conversation ended and the texting continued. Between the dates of May 10th and June 23rd, Vega and Detective Hinojosa continued texting on and off during that period. Multiple times during that several-week period, Vega would initiate the texting and there would be no response by Detective Hinojosa. On June 26th, Vega texted, oh, okay, you're not coming to see me today, with an emoji. And I replied, I don't have a ride. Carlos replied, I picked you up, silly, and continued texting. Vega then sent a text that said, well, this is the first time meeting, so I'm trying to be a gentleman, LOL. But if you want to do things, we can. I responded with, that's up to you. What do you want to do? Carlos responded with, have the letter S, a banana emoji, and a cat emoji. I responded with an emoji and says, what does that mean? LMAO. Vega replied, we can make love, LOL. Several texts later, Carlos asked, is that what you want to do? I replied with, you are talking about sex, right? I just want to make sure because I don't want to be pregnant. Mr. Vega replied, yeah, LOL. And I said, okay then. We continued texting about location and time. I asked Mr. Vega, can you grab condoms? I don't want to be 15 and pregnant. Vega replied, yes, for sure. The text continued, and it was arranged to meet at Heritage Park by the library in Taylor. Vega said he was on the way and would be in a white Jeep. I sent him a photo of the parking lot where I was supposedly at. Mr. Vega said, go by the big sign in Heritage Park, and sent a photo with the Heritage Park sign and a white pickup truck in the photo. Detective Oliver and other officers on scene identified a male fitting Vega's description inside of a black Chevy Silverado in that same parking lot. And once they stopped and identified Vega and that he matched the pictures from the chats, he was placed under arrest and transported to Taylor PD. Under a Miranda interview, several omissions were made by Vega, confirming that he was speaking with a girl named Jess on the app, and acknowledged that she indicated that she was 15 and continued talking to her. And then Detective Kopp asked him about the text using the letter S with the banana emoji and a cat emoji, and said it referred to sex.
Did you sign the complaint before you send it over to the court?
Yes.
All All right, let the record indicate I find probable cause to believe the accused committed the alleged offense, and I'll therefore issue the warrant. Anything on bond?
Requesting a high cash bond or whatever the court recommends.
Okay. All right, thank you, counsel.
Have a good day, Your Honor.
Thanks, you too. All right. Amy, I've got two I need to put on real quick.
Uh-oh. Good morning. Are you Monique Nguyen?
Yes, ma'am.
And Miss Nguyen, this is your initial appearance in cause number 24-1298. You're charged with the state jail felony offense of theft of property from April 8th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I had a lawyer.
Right, so when you're in custody, we automatically give you a court-appointed lawyer. But now that you've bonded out, what I'm going to do is give you some time and ask that you try to hire your own lawyer. So I'm going to reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the people you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, if you'll step in front of the clerk right here, she'll give you a reset notice. Jamarcus Zarate Jones. Good morning. Are you Jamarcus Zarate Jones? Did you get someone hired?
Well, I talked to 3 lawyers.
Okay.
Lori. Lori Parenzo. Corey Crenshaw, and Keith Jones.
Okay. And so where are you on being able to get someone hired? Pull your pants up. Just wearing a belt doesn't do it. Pull them all the way up so that I can't see your underwear sticking out the front. And nobody wants to see it sticking out the back. You understand? Okay. So where are you on being able to get someone hired?
I'm not physically fit.
Are you working?
No.
Why aren't you working?
Because of these charges currently.
Okay. Were you working before?
Yes.
How old are you?
I'm 21.
Okay. So you're on, have you been going to probation like you're supposed to?
Yes, ma'am.
So where do you live? Who pays your bills?
Family. With family.
Okay. Hi, good morning.
Good morning. I just wanted to make you aware, the charges haven't been filed yet. We sent over a hearing last week to second amendment because he was arrested again here in Jefferson County. So he has 2 more charges that should be filed.
What'd you get arrested for?
Just being with the wrong crowd at the wrong time.
Sounds like you are the wrong crowd. You're not? You're on probation for theft of a firearm and you've been arrested twice now? Since this, right? Is that what you're saying?
Yes, ma'am. Well, he was arrested in March, but he was also arrested June the 18th for possession of marijuana and unlawful weapon.
Have a seat in the jury box. We're going to have you tested and then I'm going to decide what to do. I guess that's still, I'd like to see that administrative hearing, but I guess it's still maybe in the process. I don't, it's not scanned into the file. I don't know if it would be still. What's her name? Ms. Martinez. Do you know if I already signed off on that last week?
And when I checked Odyssey this morning, it hadn't been scanned.
Okay, yeah, check, yeah, and if not in my box, check, Kelly probably would have already got it done, so it might still be in my box if you'll look, please, thanks. Okay. Mark Garcia. Good morning, sir. Are you Mark Garcia? And Mr. Garcia, this is your initial appearance in cause number 25-0120. You're charged with the state jail felony offense of theft of material. And that's from April 7th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Okay. I'm looking at your indictment. You have several prior offenses, so it's very important that you go ahead and try to get somebody hired before that next court date. I'm going to reset your case for about 30 days to give you some time to do that. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're not able to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the people that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice. Yes, sir. Kaylin Salzar. Good morning, ma'am. You're Kaylin Salzar. And Ms. Salzar, it looks like this is, wait, did you hire someone?
I'm just waiting on her to give you.
You hired Rife?
Yes, ma'am.
Okay, I see the letter in here. All right. And he said he was going to come this
Yes,
morning?
ma'am. He said he was gonna push for the research.
He is? Okay, I'll hold it till he gets here. Thank you, ma'am. So I gave him a bond on this MTRP. Hold on a second, let me- Mr. Coleman,
Yes.
this, Mr. Zarate Jones
Yes.
is yours. And I know you don't have it because he's on an initial, but there was a motion filed to reset a bond for his probation sometime back in April.
Did I not follow the line?
You did, which I obviously maybe took into consideration, maybe didn't take as much consideration as I should have.
It happens.
But I'm just going back through this, and so I don't know if you want to pull or just kind of look up. Apparently, we have a second administrative hearing that was filed last week that I'm about to sign, which would then get us to a second amended motion to revoke probation for these two new. So I'm going to take care of what I need to this morning, but just to kind of give you a heads up, it looks like you did file a response to that back in April, and here we are. No, you're not gonna need it. I'm gonna take care of what I need to, but, just so that you know, that's all coming.
Yes, sir. Thanks.
Thanks, Anna. Thanks, Anna. Like, who am I talking to over there? Okay, Troy Vincent. Good morning. This bond will be forfeited for non-appearance and reset at 100,000. Hillary Lawrence. Good morning, ma'am. You're Hillary Lawrence.
Yes, ma'am.
Miss Lawrence, were you able to get someone hired?
No, I spoke to like 4 different lawyers, and one of them preferred to Betty. I'm sorry, I can't say his spell R.
Reynolds.
Yeah. He started 5,000. I'm not able to.
Who else did you talk to? A few others? You said?
Jonathan, the Carters. I talked to them. I talked to the Watson firm. They don't do my cases. And Harrison Davis, they don't do costs. They also don't do my cases. And Navy law.
Okay. Are you working?
Yes.
Where you work?
McDonald's.
Okay, so I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Thank you for doing what I asked and contacting those lawyers. You're gonna step in front of the clerk. She's gonna give you that paperwork. Make sure you fill it out accurately and completely. You're gonna swear under oath that everything's true and correct in it, and then I'll take a look at it. Okay? Ronnie Oliphant? Good morning, sir. You're Ronnie Oliphant. And Mr. Oliphant, did you get someone hired?
No, ma'am. Almost there. I was trying to see if I can get the next extension.
Who are you trying to hire?
It was someone out of Houston that I was referred to. They had 100,000. I almost had the next.
What's the name of that attorney?
I'm not sure. I had the paperwork.
Where?
It was in my residence. I think in my car, man. I just gave him a call one time and I was just gonna hire him.
Okay, so you didn't think it, when you were here before and I said, go talk to some attorneys or get someone hired, bring me the names of the people. So I need that name. I need to know what you're gonna do. Because if you didn't talk to 3 and you're planning on hiring this one, I wanna know who it is so that next time you come in, I know that you're doing what you're saying. So I need you to figure out who it is.
Yes, ma'am.
I'm gonna hold your case for just a few minutes, figure it out. Don't leave, because I'm gonna recall you back up here.
Okay.
So go figure out who it is that you talked to and who you're gonna hire.
Okay.
Lisa Pratt. Lisa Pratt.
No response, Your Honor.
Bond will be forfeited for non-appearance and reset at 100,000. Martin Ward. Good morning. You're Martin Ward. Speak up, please.
Yes.
And are you sick, Mr. Ward?
No, but I heard my sister-in-law.
I can't, so since, if you're not sick, if you'll just pull it down while you're standing up here away from everybody, so I can see your face and hear
My
you.
sister-in-law, both my sister-in-laws got COVID.
Okay. No, I appreciate that. And Mr. Ward, were you able to get someone hired?
Not as of yet. I interviewed 5 attorneys and I decided on narrowing down to 2.
Who's that?
And both attorneys are requiring much payment.
Just tell me who it is.
Okay, it's Scott Linick.
Mm-hmm.
And I'm trying to do the last attorney, someone that I have that between that law firm and the same law firm, I'm pretty much go.
Okay, who's the other?
Scott Linick and Benjamin Jeffries.
Okay. So if I give you one more reset, you think you'll be able to get one of them hired?
Probably need about 60 days.
Well, I only give 30-day resets, so let's do this. I'm gonna reset your case 30 more days. If you're making payments to one of them or saving up, that's fine. Make sure you give me that information when you come back. If for some reason it's not gonna work with those 2, there's lots of other attorneys that have different payment plans, charge different amounts, contact some more, bring me that information. If you do get someone hired, just bring the reset notice that you get today to them and they'll tell you what to do, okay? All right, if you'll step in front of the clerk. Shaniqua Washington. Good morning, ma'am. You're Shaniqua Washington. And Miss Washington, did you get someone hired? I'm sorry? I need you to speak up. So you already hired him and paid him money on this case? So when you were here before, I told you you had to hire a lawyer, right? So he's not just going to be your court-appointed lawyer down on this case. All right?
But he told me to represent, so you want me to highlight, but he told me to represent him with this case too.
Well, but you have to hire him to represent you. I'm not going to appoint him if you made bond. I gave you those rules when you were here before,
Yes, ma'am.
right? So I need you to try to hire someone. It can be him, it can be whoever.
Okay.
If you can't afford to hire someone, you don't know that if you don't talk to some lawyers. That's why I ordered you to talk to at least 3, because they all charge different amounts. They all have different payment plans. These are the same things I said last time.
Yes, ma'am, I had talked to him, told me he was going to do it, but I don't see it.
But if you didn't hire him on this case,
I understand.
then he's probably not going to be here. And I don't know if he has something on, or does Joel have something on our docket today? But you need to talk to him about actually hiring him.
Okay.
Because I won't just appoint him because you were appointed down, because it's just different down here on this court. He's not, he's not supposed to be on our docket anyway, so I'm gonna reset your case 30 days. Talk to him about hiring him, okay? If that works out, great. If it's not gonna work out hiring him, talk to some others, bring me those names, and we'll discuss your options, okay? All right, step in front of the clerk. Donnell Coleman. Good morning. Are you Donnell Coleman? Ms. Coleman, were you able to get someone hired?
Not someone hired, but I did talk to 3 attorneys, and I got the shortest quote, like during the period of my case pending. I had to quit one job, but the shortest quote that I got was $800 from a guy, because I spoke to Charles Ross, I spoke to Thomas Burbank, and it was a guy out of Galveston. I was referred to him, Harry Smotherman, and he quoted me the cheapest one I got was $800. And so I told him that I would get back in touch with him because I wanted to start working again.
Okay.
I just got a new job.
You did? Okay.
And didn't go back on the pending case that I have now.
Okay.
And so I was moving forward with going to him since he gave me the cheapest quote.
Sure. So you think if I give you a little more time, you'll be able to maybe save up and get him hired?
Okay.
Okay, so thank you for talking to those lawyers. I'll give you another 30-day reset or so. If you get them hired, great. If for some reason that's not going to work, talk to some others. As you can tell, they all have different payment plans and charge different amounts. Bring me those names and then we'll discuss your options. If you do get them hired, just bring that reset notice that you get today to who, and he'll tell you what to do, okay?
Okay.
All right, step in front of the clerk. Yes, ma'am. Shadamon Mitchell. Shadamon Mitchell. Good morning. Good morning, you're Shadamon Mitchell?
Yes, ma'am.
And were you able to get someone hired?
Yes, ma'am.
Who'd you hire?
Dunham Jones.
Okay. Or which one?
I'm not sure. He said he would meet me here today. I'm sorry, this is my first time.
No, that's okay. So the lawyer's supposed to be here this morning?
Yes, ma'am.
Okay, so what I'm going to do is just hold your case. You can either have a seat here in the courtroom or right outside the courtroom. If you'll let the bailiff know when they get here, or have him let the bailiff know, then we'll take care of what we can, okay? Don't leave until I'd say you can leave. Yes, please, that would be great. You can go back, you can step out. Zachary Turner. Good morning, sir. You're Zachary Turner. And Mr. Turner, were you able to get someone hired?
Not hired, but I'm leaning toward hiring Mr. Lincoln. I spoke to somebody at his firm, like Ms. Holmes, she quoted a little higher. I can kind of like 850 saved up, and if they both want like 5,000 down. So,
Okay.
work on that.
And are you working?
Not at the moment. I just got my ID and stuff. As you can see, I'm on parole. I just got out. I'm just getting everything.
Sure. Okay. Since you did, I mean, do you want me to have you fill out, you want to fill out some, you've done what I asked you to. Do you want to fill out some paperwork to see if you qualify for a court-appointed lawyer?
Yes, ma'am.
All right, step in front of the clerk. She's going to give you that paperwork. Make sure you fill it out accurately and completely, and then I'll take a look at it.
Yes, ma'am.
Anthony Salvato. Okay. Good morning, sir. You Anthony Salvato? And this is a motion to revoke probation, Ms. Malfino?
Yes, ma'am, Judge. He is not clinically eligible for VA healthcare. However, he is participating fully in the U.S. Vets Houston program, which is a program for his mental health, housing, working, et cetera. I have corresponded multiple times with them. Is everything still going well?
It's awesome. This is the best thing that's ever happened to me.
Okay, and so I kind of talked to him about trying to stay involved in that as opposed to hiring necessarily a lawyer at this juncture.
Sure.
And I was wondering if the court would consider maybe allowing us to hold this motion for some short period of time, make sure he is well established in that program. I just hate to see this motion disrupt him from everything that he's doing with that. And I have received continual updated correspondence from them saying he is doing everything they've asked.
And it looks like I have as well. They sent me a letter in May with the same thing. Yeah. So let's do.
I can't tell you how well I'm doing.
That's great. It's when you find the right place that it's very helpful. So here's what I'll do. I'm just going to reset the case about 60 days based on what Ms. Malfino is telling me. Keep doing what you're doing. Stay in touch with probation, make sure they know everything that's going on, and then we'll see where we are in 60 days.
And I'll update Mr. Vuitton as well. He's aware.
Perfect.
of probation.
Okay, thank you. Thank you, sir. Good luck.
Ashley, who still needs to sign.
Oh, yeah, we need you to sign your reset notice still. Dontrell Scott.
He's by the council, Your Honor.
Good morning, Mr. Johnson.
Morning, Judge.
All right, so looks like you were here. This is his initial appearance, so you were just hired. I don't even see if we've gotten a letter yet through e-file.
Everyone has it, I mean, it's.
It's probably on its way.
It is, Your Honor.
You just need some time then to get everything?
Yes, Judge.
So, Mr. Scott, thank you for taking care of hiring a lawyer. I'm going to reset about 30 days or so
Yes, Your
to
Honor.
give Mr. Johnson time to get the discovery in your case, and then we'll get an announcement the next court date.
Yes, ma'am.
All right?
Thank
Thank
you.
you. Yes, sir. Hey, Rife. Mr. Kimler. Kaylin Salzar is on my initial.
Yeah, I should have been filed.
So she has hired you? Ms. Salzar? You're free to go, ma'am. Stay in touch with Mr. Kimler and your bondsman. They'll let you know when your next court date is.
Yes, ma'am, thank you.
Yes, sir. Yes, ma'am. If you'll just make a note of that, so we make sure we get that, that it comes through. Here's this one that qualified. Okay. Mr. Macon?
Yes, Your Honor.
You have Fernando Flores?
Yes, Your Honor. Your Honor, I have all the.
Hold on just a second. Is Ms. Malfino, did she step out?
She did, Judge. I'm ready.
Corey Lawrence.
All right, sir, you're Fernando Flores, and this is 24-2354. Mr. Flores is charged with boating while intoxicated with a child passenger. Mr. Macon?
Yes, Your Honor, I have all the discovery and a plea offer and video. However, Mr. Flores has been working in Alabama, and our schedules just haven't worked.
Sorry.
However, he's only working there 2 more weeks, so a 30-day reset, I'll be ready to make an announcement.
Okay.
Publicly.
And it looks like you were just hired in May. So what I'll do, Mr. Flores, is reset your case about 30 days. Regardless of work, you need to make an appointment visit with Mr. Macon before that next court date, okay? And then we'll see if we can get an announcement. All right, you're free to go. Thank you. Mr. Wilkerson, you have Kimberly Scott sentencing.
Yes, Your Honor, I also have one, well, I'll go ahead and take care of this one.
Okay. Kimberly Scott. This is Mr. Hoffpowers. Good morning, ma'am. You're Kimberly Scott. And Ms. Scott was previously in court, entered a plea of guilty in cause number 250470 to the state jail felony offense of abandoning or endangering a child. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Are there any additions or corrections?
Nothing from the defendant.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the conviction on your record. You're not a convicted felon. And at the end of the probation period, if you successfully complete it, the case will be dismissed. You'll never have a conviction on your record. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and then you could be sentenced to the state jail prison for up to 2 years. Do you understand? And it sounds like everything is going well. You did everything you were supposed to with CPS. Kids are back with you. We talked about this, I think, before, and obviously it sounds like this is something that was out of character and that we shouldn't expect to happen again. So, all right, I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat in the courtroom. When probation's ready to go over your paperwork, she'll call you back up to her desk, okay? All right, good luck to you, ma'am. And did you need some time on Paul Castillo?
Yes, Your Honor.
I'll hold it. Mr. Rojas, you have a sentencing on Chad Smith. It's a sentencing on Chad Smith. Okay.
That mystery is going to be dismissed this morning.
Okay. Good morning, sir. Are you Chad Smith?
Yes, ma'am.
And Mr. Smith was previously in court in cause number 242309, entered a plea of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
Just an update, Judge. Page 3 shows that Mr. Smith is unemployed. He tells me that he's been working for about 3 weeks at Post Contractors. He's a foreman out there, making about $21 an hour.
So I know y'all know what my concern is here, that there were 2 felony probations just in the last 5 years that were revoked in the last 3 years. 2 different probations, one here and one in Brazoria County. So I don't have good warm fuzzies about you being successful on another probation.
Can I say something?
Mm-hmm.
That was a whole another life ago. I've corrected my life. I've been sober for 3 years now. I've been focusing on nothing but working. Disobeying arrest was actually a discrepancy that I didn't pull over fast enough with the officer. And I haven't been living that way in over 3 years now. So if you give me a chance, I'll show you that I can do it.
Okay. Mr. Smith, any reasons not to go forward then? All right, so I'm going to give you this opportunity. I do hope you take advantage of it and that you really have made those changes. I'm going to find sufficient evidence to find you guilty. and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with the agreement you made to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm suspending that. You'll be placed on probation for 6 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then as you know, for all practical purposes, your case here in court is over. You'll be able to serve that sentence while you're out on probation. The other side, however, in this case, is you've already agreed to a 10-year sentence. So if you violate your probation, you have that 10-year sentence hanging over your head. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. You've probably already received that, but I'm required to read it. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. And it's my understanding there, take him down there, and something's gonna happen on that misdemeanor this morning.
We're gonna dismiss it, Judge, so.
Okay.
I can walk down and see if I can find which one is it.
I think it's county court 3.
I can walk down there.
Okay. Okay, as soon as, so if we can just hold him, if you'll come back and let us know as soon as that's signed, so you don't have to get transported or anything like that. Okay, yes, sir. And Carnell Beard, Mr. Rojas. Good morning, sir. You're Carnell Beard? Yes, ma'am. And this is 24-2414. Mr. Beard's charged with collision involving serious bodily injury. And Mr. Rojas, what's the announcement?
Judge, we do have an offer in this case. I asked for another reset. Mr. Beard wants to give me some documentation that I can forward to Ms. Morfino that hopefully will help us out.
Okay.
To get a better offer.
Any issues? No. All right, Mr. Beard, I'm going to reset your case about 30 days. Make sure you get that information to Mr. Rojas quickly so he has time to get it to Ms. Morfino and they can visit about it before that next court date, okay? Yes. All right, you're free to go.
Thank you.
Yes, sir. Mr. Jones, come back up, please, sir. So you only tested positive for amphetamines, and it looks like you have a prescription, but I want to go through real quick. Hold on, let me read this police report real quick about your last arrest. All right, so Mr. Jones, obviously, hold on a second. You're on probation for theft of a firearm. You've been arrested, what, just last week, week before last? And were able, I guess, did you make a bond in the new case?
Yes, ma'am.
because you're on probation for the felony offensive theft of a firearm, and because you were arrested in a vehicle that looks like, allegedly, obviously you've not been charged with it, but there was marijuana in the car near the seat where you were sitting. It smelled like y'all had been smoking marijuana, and there was a gun in the glove box where you were sitting. So I'm going to find that the bond that I set in the motion to revoke your probation case is not in the best interest of our community. I'm going to find that because you've been arrested while you were on that bond, that it is appropriate for me to raise that bond. And at this time, I'm raising your bond to $200,000. You can go back with the bailiff. Hand it to the bailiff. You gotta try harder than being in a car with a gun and marijuana while you're on probation. You've got a motion to revoke your probation. Go with the bailiff. We'll figure it out. We'll get you a lawyer appointed and we'll figure it out. Trying to go into the morning, which is probably the best place, but you're on probation, can't go anywhere. Yes, on the MTRP, just on the MTRP at this time. Yes. This one qualifies. Let's see, Mr. Johnson was Mr. Are you visiting on Ramona Houston?
Yes, Your Honor, actually.
Okay, I'll hold it. Take care of it as soon as it's ready. Thank you, sir. And then, Mr. Kimler, you have James Wheeler sentencing. There was no agreement, correct?
Yes, I agree.
Good morning. Are you James Calvin Wheeler? And Mr. Wheeler was previously in court. This is 23-1800. Mr. Wheeler's on probation for fraudulent use or possession of identifying information, a state jail felony. There was a motion to revoke filed, pled true to all of the allegations in that motion to revoke. And what is the announcement?
Well, Judge, this is,
I mean, not what's the announcement, what is, I guess, what's your position?
after reviewing the
Good morning, sir.
recommendation from probation and some of the documentation that's been provided, I'm in agreement with continuing on probation. I'll note that the recommendation from probation may note that where'd it go? That he's demonstrated his ability to stay sober, that the CPS involvement, they even noted his exceptional cooperation and things like that. So based on that, I don't have a problem with continuing on probation at this point, Your Honor, if the court should agree.
So what kind of treatment are you receiving now? What are you, anything, have you completed what you had started with?
I completed everything, I done the pregnant house, and then I was with the CPS, and then we did, much more. Now, I'm full-time working, 50 hours a week. So pretty much just all I'm doing is working and sleeping.
Can I ask probation a quick question?
Sure, please.
Are there any programs that you think he needs moving forward, or anything that would help him?
I just want to make sure we maintain sobriety.
He needs to continue doing AA.
So, Mr. Wheeler, part of what concerned me here was that for some amount of time, you didn't turn yourself in, you absconded, and I understand that you went and did treatment, but you don't get to make those decisions on your own when you're on probation. So if a motion gets filed, if there's an administrative hearing, whatever it is, if there's a warrant for your arrest for some reason, you don't get to say, well, I'm going to go run and go do treatment, which is great, and I'm glad you did. But if something happens in the future and you relapse and you decide, well, I'm going to go do what I need to do and not what probation's telling me to do, we're not going to be having the same conversation. Okay, so based on the pre-sentence report and how you're doing, I am going to find that you entered your pleas of true to all of the counts freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation, order that you continue doing everything that probation says you need to, all the classes. If there's some issue and they feel like you need more treatment and they say you need to go to JCDI or they say you need something inpatient, it will be required, or you will be back in here looking at that 2-year term that you already have agreed to. Do you understand? You are substantially behind in your fees. Now that you're working, you need to make a concerted effort to get those paid. At least start whittling down how much you are behind. Anything else, Mr. Nichols?
I think that covers it, Your Honor.
Okay, so I'm going to hand you actually, if y'all will sign that and just give them the bottom page. That's just showing that this wasn't an agreement. You have some rights. You can talk to Mr. Kindler about that. Just stay in touch, obviously, with your probation officer and continue doing hopefully as well as you have been.
Yes, ma'am.
And you can just give him the back page. Mr. Kindler, please.
Thank you, Your Honor.
Thank you. Thank you, sir.
Zachary Turner.
Mr. Parker, you have Timothy Horace. Anna, I don't have anything on here, do I? Should I have? Oh, okay, I just thought you had some over there. I feel like I saw one and now it's blank. I thought there was one on here. But I have nothing now, it's all just blank. Good morning, are you Timothy Horace Jr.? And this is 24-2259. Mr. Horace is charged with obstruction or retaliation. Mr. Parker?
We have plea paper.
Oh, this is, yeah, everything just went away on mine. Do you want me to, is there a way for me to refresh or something?
No, ma'am, because I don't see it.
Y'all just have a seat for a minute. We're going to find your paperwork hopefully somewhere and y'all won't have to do it again. Just have a seat in the courtroom for a few minutes.
I know she sent it, and she got it, but she couldn't go.
Well, there was something here a minute ago on mine and now it's gone.
That's why I called it up.
Yeah,
Now it's
gone. Let's take care of your sentencing on Richard Rogers, Mr. Parker.
Okay.
I know, just gone. Because I knew I saw something and she's been swearing some people in. Good morning, are you Richard Parker Rogers?
Yes, ma'am.
And in 24-2336, Mr. Rogers was previously in court, entered a plea of guilty to driving while intoxicated, third or more, and received the pre-sentence report. Is there any, has everyone had an opportunity to review that report?
We have, Your Honor. Yes.
Are there any additions or corrections?
No, Your Honor, not from the state. Only thing we're asking, Judge, is that he be allowed to do his 10 days on weekends. He has a job. I'm actually related to him, and he is on his own. He went to rehab and through the help of his mother and has continued to do aftercare, and the family's been very pleased with what he's done. And he's
Good.
made arrangements with his job that it won't affect his job to be able to do the 10 days on weekends.
Any issue with that? And do you have a vehicle?
Yes, ma'am.
And does it have the ignition interlock device in it?
Yes, ma'am.
Okay. And you know you can't drive any other vehicle other than that one that has that in it, right?
Yes, ma'am.
Okay, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years, excuse me, in the institutional division of the Texas Department of Corrections, but suspend that and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That does include that 10 days upfront time that will start this coming Friday, July 4th at 6 p.m. And then you're going to go every weekend until you satisfy those 10 days. It's very important that you're on time. You get there at 6 o'clock. You're not late. It's very important that you're sober when you get there. A lot of people think that they're going to show up drunk or whatever and sleep it off over the weekend. It's a terrible idea because you'll be in violation of your probation very quickly. You'll have to follow all of the other rules and conditions of probation. If you do that, then this is a great opportunity because for all practical purposes, your case here in court is over and you'll be able to serve that sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you have agreed to a 10-year sentence in prison. You can be brought back into court, your probation revoked, and you could be facing that 10-year sentence. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
Thank you.
I see one thing came through, a plea bargain rejection, but we don't know. Oh, well, try. Okay. Okay. Mm-hmm. I've never had this where something was showing up and then it's just gone down here. I haven't.
Paper is a lot simpler. It doesn't just go away when you're signing it.
I know, right? See, Mr. Lewis, you have Justin Wallace.
Yes, ma'am.
I do have that one on here. Morning. All right, sir, you Justin Dwayne Wallace, and this is 24-1590. Mr. Wallace, you're charged with a second-degree felony offense of indecency with a child by sexual contact from October 1st of 2021. Your indictment alleges you were previously convicted of possession of a controlled substance, a second-degree felony, March 21st of 2006, in 2 cases on that same day. What that means is that if you go to trial in this case and you're found guilty, your punishment would be enhanced to that of a first-degree felony, which is between 5 years and up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection that has your signature on it with Mr. Lewis's here that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a cap of 15 years in prison. And I know Mr. Lewis has gone over that, but what that means is that if you wanted to take that deal, you would be leaving your punishment up to me. And if I followed the agreement, I could not give you more than 15 years. I could give you 15, I can give you less, I can consider probation. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am, I do.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. And so, Mr. Wallace, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him today. I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
I want to keep it.
Okay, that's fine. So Mr. Lewis will remain your attorney. We'll set it on the trial docket and he'll begin preparation for trial. And we've already got CPS records back and everything that we were waiting on,
Right,
correct?
that's what we're waiting on.
Okay,
We got 'em.
perfect. All right, we'll get it set for trial. Stay in touch with Mr. Lewis. He'll let you know when you need to be back. Mr. Lewis, on Jaron Crane, is that one that you had paperwork working on or no?
No.
All right, so Jaron or Jerron Crane?
May go off the record.
Sure, Jerron Crane. See, Mr. Parker, what about Timothy Horace? Is that the one we're waiting on? That's the one that's lost. I'm getting some others come through. Y'all might have to. Let's see. It's Mr. Frank, Jonathan Frank. Mr. Nichols, have you heard from Mr. Frank on DeAndre Smith's case? Okay, I'll hold that. Is DeAndre Smith here? Have you heard from your lawyer? No, well, just, do you know if he's coming today?
No.
He's not coming? Okay, have y'all heard from him? Anything? Yeah, come on up. What did he tell you?
Well, I be on him or text him, so I can I kind of took a conclusion. I'm trying to do like a withdrawal with him.
Okay.
Because it's like he's coming from Houston, but it's like.
He's not coming.
I know about the payment, but it's like, I only got the discovery. You know what I mean? I don't.
Yeah. All right.
So I was gonna talk to you about, see if I can get through there and sit to.
Yep. So what I'll do is reset your case about 30 days. Make sure you start talking to other attorneys soon. Don't wait to the last minute, because if you do get someone else hired, they'll need to file the appropriate paperwork to substitute in, okay?
Correct. I had got the brief from last time we talked about, I had hired him prior, and paid him like $1,800, but it's like, you learn about the payment, which ain't a problem, but it's like, I don't even know what's going on.
Sure. Well, okay, just, you'll get about 30 days or so. He's still your attorney. Stay in touch with your bondsman. They'll let you know when your next court date is. Okay?
Yes,
All right, you're free to go.
The bondsman's gonna let me know.
Yes, keep in touch with your bondsman for sure each week like you're supposed to, and they'll let you know when your court date is.
Yes, ma'am.
Okay, yes, sir. See if we see Mr. Burbank and Mr. Adams. Okay. Mr. Okay.
Judge,
Yes.
on this Houston's case with Mr. Johnson, so we know what we're doing. You'll know the age and offense date. It's a 5-year-old DWI.
Okay.
I'm doing a reduction to a Class A, with, she did 5 days in jail when she was arrested.
Okay.
She's currently enrolled in a veterans treatment program in
Okay.
Houston. So I'm trying not to interfere with that, just have her continue that, with this being 5 years old.
Yeah.
That's why it's a
And I
reduction
think-
in the light sentence.
Technically, I think giving credit on that isn't what we are supposed to do, but if there's nobody that argues it, then that's fine with me if you're okay with that. Okay, as soon as it comes through, I'll take care of that. Let's see, Mr. Wilkerson, you've got Paul Hernandez Castillo.
Yes, Your Honor. Good weekend.
I did. How about you?
It was pretty good. Got to rest.
That's always nice.
Yes.
Good morning. Are you Paul Hernandez Castillo? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Castillo, in cause number 250187, you're charged with the state jail felony offense of solicitation of prostitution from December 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred adjudicated probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Castillo is not competent?
There is not.
And Mr. Hoffpower, since this is a state jail, is there any history or?
No history on it, we don't mind. Yes, sir.
Okay, so then, Mr. Castillo, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney, defer all proceedings for a period of 2 years. You'll be placed on probation. You're ordered to pay the fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed and you will never have a felony conviction. The other side to that is if you violate any condition of probation, you can be brought back into court. You could be found guilty of the offense and you could be sentenced to the state jail prison for up to 2 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You just need to have a seat here in the courtroom. There's a lady sitting at that desk right there with probation. She's going to call you up to go over your paperwork when she's ready, okay? All right, good luck to you, sir. Mr. Johnson on Ramona Houston.
Ms. Houston, Your Honor.
Good morning, ma'am. You're Ramona Houston?
Yes, ma'am.
Let me get this pulled up. And Mr. Johnson, will she waive the formal reading of the indictment?
We will, Your Honor.
And it looks like the state is proceeding on the lesser included offense of a Class A misdemeanor DWI. Is that correct?
Yes, Your Honor.
Let me get it. All right, Ms. Houston, in cause number 21-36380, again, the state's elected to proceed in the lesser included offense of a Class A misdemeanor DWI, and that would be a DWI second or Class A
Second.
because of the amount?
A second.
A second. And that is from October 4th of 2020. It alleges that you were previously convicted of driving while intoxicated March 15th of 2013. And how do you plead to that charge?
Guilty.
And is that prior offense true? Conviction. Are you entering your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Johnson?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And the agreement is for 5 days in jail and that you have credit for that, is that correct?
Yes, Your Honor, I checked. She served 5 days.
Okay.
She was initially arrested.
State tenders number 1.
Without objection, Your Honor.
It's admitted. Is there any evidence that Ms. Houston is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of driving while intoxicated. Sentence you in accordance with your agreement to a term of 5 days in the Jefferson County Jail. You will get credit on that sentence for the time that you were in there before for those 5 days. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. And Mr. Nichols had previously mentioned, it sounds like this is obviously an old case for whatever reason. You're doing great, and I think that's the reason for this plea agreement.
And she's participating in the Veterans Treatment Program in Houston, Your Honor, and our wish is that that not get interrupted, that she continue her progress there.
Perfect. Good luck to you, ma'am.
Thank you.
Thank you, Mr.
Thank you, Your
Johnson.
Honor.
Mr. Johnson, do you have your discovery certification? Ma'am, don't leave yet. If y'all will get that signed real quick, Mr. Nichols will.
3914, yeah.
Thank you. Mr. Lewis, on Deshauna Bass. I heard the sigh from over here. You giving Mr. Coleman a hard time this morning?
He needs it. I'll even know, but I can tell you need it.
Deshauna Bass.
Yes. We had.
Take care. Good morning. Are you Deshauna Bass? And Ms. Bass is charged with assault on a peace officer in 242316. And what's the announcement?
Judge, I was talking to Mr. Copeland. We've been trying to come to a resolution on this one, and he's made us an offer on this case. And I'm talking to my client. I think it may be best before we either accept that offer or set it for trial, if I get her in the office so she can look at the rest of the body cams herself
Okay.
to make that decision.
All right.
And then we'll definitely be ready to move the case by the time we come back.
All right. Any issue, Mr. Coleman?
No objection.
All right. So Ms. Bass, I'm going to reset your case about 30 days. Make sure you call soon and make an appointment so you have plenty of time to go in and visit with Mr. Lewis about your case, watch any videos, look at the discovery he has, and then talk about your options, and we'll get an announcement at the next court date. Okay? Thank you. Ms. Holmes on Isaac Talley. Did you ever find?
I'll read your paperwork.
Y'all redid it? Okay.
And I can see that it went over to you and then.
Good morning. Are you Isaac Talley? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Talley, in 24-1997, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from August 26th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 3-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Talley is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll just give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there, okay? All right, we'll see y'all back at sentencing.
Thank you.
Ms. Holmes, you have a sentencing on Devontae Savoy.
Yes, Your Honor.
Devontae Savoy.
He's outside his grandmother.
I'm going to test him before I. Good morning. You're Devontae Savoy. Mr. Savoy, before we go forward with your sentencing, I'm going to have you tested to see if there's anything in your system today. Have a seat up there. Okay. I want to see what all's in there for sure. All right. Have a seat. Y'all need to maybe discuss his age and where he's probably going to go if he can't stop using, because I'm not going to. I mean, 18 years old, juvenile stuff. I'm thinking ISF is going to be my typical if he's unable to quit doing this on his own, knowing he's waiting on court, you know. So let me see what all is in his system, and then you might want to talk to him. Dominique Richards, Ms. Holmes.
Yes, Your Honor.
Good morning. Are you Dominique Richards? Speak up, please. And Ms. Holmes, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Richards, in 25-0141, you're charged with the state jail felony offense of solicitation of prostitution from December 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Said it too many times today. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Richards is not
No,
competent?
Your Honor.
And Mr. Hoffpower, any Since it's a state jail felony, any issues that you
Judge,
see?
don't have an issue, doesn't have a criminal history, or it doesn't have any felony.
All right, so no opposition to waiving the pre-sentence report?
No to the state.
All right, Mr. Richards, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings, place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you're successful, the case is actually dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's sitting at that desk right there. She's going to call you up when she's ready to go over your paperwork. Good luck to you, sir. Let's see, you have Ashley Renfro. Good morning. Are you Ashley Renfro? And in 242402, Ms. Renfro is charged with driving while intoxicated with a child under 15. What is the announcement?
Your Honor, if we could get a little bit more time. Ms. Renfro's gonna work on getting some documentation, medical records for me that
Okay.
I'd like to provide to the prosecutor.
Any issue?
Oh, yeah.
All right, so I'm going to reset the case about 30 days or so. Make sure you get that information or any documentation to Ms. Holmes soon so that she can get it to Mr. Hoffpower. They can review it and talk about it, okay?
Yes.
All right, we'll see you back in about 30 days.
Thank you.
Mr. Parker on Timothy Horace Jr. Try this again. All right, so you are, again, Timothy Horace Jr. And will your client waive the formal reading of the indictment?
No, Your Honor.
Mr. Horace, in 242259, you're charged with the third-degree felony offense of obstruction or retaliation from September 25th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated and you'd be on probation for 5 years. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. DeHorst is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report done from probation. It'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay, we'll see you back at sentencing.
Thank you.
Mr. Rennick, you have a Kendrick Walker.
Yes, Your Honor.
Good morning.
Good morning, Judge.
Good, how about you?
You know, serving the people of Southeast Texas.
That's right.
How for it, Judge.
All right, sir, you Kendrick Walker? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Walker, in cause number 240196, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from June 26th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rennick? Do you fully understand them? Answer out loud, please. And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be suspended and you'd be placed on probation for 5 years. You would be ordered to pay a $500 fine and follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Sorry. State tenders number 1.
No objection, Your Honor.
It's admitted. Any evidence that Mr. Walker is not competent?
No, Your Honor.
Is there something going on with your computer? Hers.
Yes.
Okay.
Yeah.
Mm-hmm. All right, I'm going to find, Mr. Walker, that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Thank you. Have we heard from Mr. Burbank? Ms. Holmes, you have LaMarcus Liggins?
Yes, Your Honor.
Good morning, sir. Are you LaMarcus Liggins? And this is 242391. Mr. Liggins is charged with theft of property with previous convictions. Ms. Holmes, what's the announcement?
Yes, Your Honor, we do have an offer from the state. If we can get one more reset, I need to get some paperwork in regards to time from another county.
Okay.
That we need to see if we can verify.
Sure. Any issues?
No issues, Your Honor.
All right, Mr. Liggins, I'm going to reset your case about 30 days or so. Make sure you stay in touch with Ms. Holmes. She'll let you know when you need to be back for your next court date. Thank you.
Thank you, Your Honor.
Mr. Adams on Sierra Jackson.
We sent the plea offer rejection on that one to you, Judge.
I've got it.
And she's here.
It's 30th, right?
Yes, sir. Good morning. Are you Sierra Jackson? And in cause number 242429, Ms. Jackson is charged with unauthorized use of a vehicle, which is a state jail felony, and that's from October 28th of 2024. And what that means, ma'am, is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Adams that shows that the state has made an offer, if you wanted to enter a plea of guilty, for a 3-year deferred adjudicated probation. Looks like, is that $500? $500 fine. You have every right to reject that. I just want to make sure you understand what the possible consequences are and what your options are if you go to trial. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Set for trial.
All right, and is there any reason, Mr. Hoffpower, to believe that that offer would change?
Your Honor, can we withdraw once it's rejected?
So, Ms. Jackson, I want to make sure I'm sorry?
It's withdrawn now at this point.
I want to make sure you understand that after today, and if you're not guilty, that's what we have the trials for, but I want to make sure you understand that I will not accept this plea agreement after today. If you change your mind, you could enter a plea of guilty just open to the court or to some different plea agreement, but not this. Do you understand? Okay, we'll get it set for trial. Stay in touch with Mr. Adams and he'll begin preparation for trial. Michael Spain, Mr. Adams.
He's here, and I have that case with Mr. Coleman.
Hold on, let's get everybody up here. Good morning, are you Michael Spain? And Mr. Spain, in cause number 241120 is charged with aggravated assault with a deadly weapon, and what is the announcement?
Just announcement is I'll be filing a motion to withdraw on that case for a contract situation, but I have made him aware of the offer is 5 years, and he's also aware that he's an habitual, looking at 25 to life. However, and Mr. Coleman has said that as of today, if he doesn't take the 5 years, that offer is no longer on the table. But I explained that to him, but again, with our contract situation, I can't try that case for free. And he's aware that, he's gonna have to fill out the paperwork for a court-appointed lawyer. So
Okay,
I'll
so
file that today.
let's start off with Mr. Spain. I want to make sure, it looks like there's been an offer. You've talked about that offer with Mr. Adams, and that if you reject that offer today, which is fine, it sounds like Mr. Coleman is not going to extend that offer again. Is that correct, Mr. Coleman?
No,
Or
Judge, but I will say, in the interest of full disclosure, it's one of the judgments or priors that I'm relying on is from the state of Virginia. And I need to do some research to make sure that it was actually a final conviction.
Gotcha, okay.
So if it is in fact a final conviction, Judge, I will be filing a habitual offender notice.
And you've gone over that with Mr. Adams. So what I'm going to do today is just reset your case, normal reset. Mr. Adams, if you intend to file something, get that done quickly, and then we'll take it up at the next court date.
That'd be fine.
All
Thank you,
right. Stay in touch with Mr. Adams and your bondsman. They'll let you know when you need to be back. You're free to go. And then you've got Xavier Clayton.
I think you guys released him,
Oh, okay. Thank you.
and I think that's all.
Yes, sir. Thank you.
Thanks.
Can y'all check and see about Mr. Burbank? Okay. And then, is Savoy getting drug tested? Okay. And then I think that's it, right? Savoy and Mr. Burbanks? Mr. Oliphant? All right, who's the lawyer that you intend to hire? I'm sorry?
Dunham and Jones.
Dunham and Jones isn't the name of a lawyer, it's the name of a firm.
That's the firm, or with the referral, and I was gonna hire them.
Who, but you, did you talk to a lawyer?
Yes, ma'am.
So you don't remember who you talked to?
He was Dunham, but that's the firm,
Okay,
Houston.
all right. I'm gonna reset your case one more time, about 30 days. You need to get them or someone hired before that next court date, okay? If for some reason you don't, you need to talk to some other lawyers. You need to write down a piece of paper, who you talk to, what their names are, and bring me that information, okay? Step in front of the clerk, she'll give you a reset notice. What did I, okay, I took care of that one. And then, yeah,
Karen said that she was trying to explain something, but I haven't had an opportunity to speak with her. We were waiting for her to turn the shoulder.
Ms. Mitchell? What were you trying to explain?
The lawyer name is Joseph Lindbergh. I was calling the law firm, but it seemed like they got it mixed up. Supposedly they have them on file that is from Chambers County.
Okay, and it's Joseph Lindbergh?
Yes, ma'am.
And where are they located? Do you know?
Get the address on the phone?
Mm-hmm. I mean, what city?
Oh, I hear in Beaumont.
Joseph Lindbergh
Yes, ma'am.
in
But
Beaumont.
it's Dunham and Jones law firm. She said she would have to get in touch with someone named Chris.
I don't know any of those that have been Jones that do criminal stuff. I don't know where y'all are getting. No, I can, okay. So, did you pay on money?
Yes, ma'am.
You
We
did?
made 3 payments so far of $200 a piece.
Okay. All right, if you'll just do a reset for 30 days, you need to try to get them hired before that next court date, and make sure you write down that Joseph Lindbergh on the reset for me.
Yes, ma'am.
Thank you. Step in front of the clerk. We have a new lawyer in town. or what?
Your Honor, that firm is out of Austin, because I've had a few, I think two-
Maybe they just have a local
they
number or
sent me,
something?
Yeah, like to sign off on substitution, and they're out of Austin. Yeah, they must be advertising a lot here now. They've sent me two.
Well,
like within the last-
I hope.
Pops up as Judge County Criminal.
There you go.
Oh, it does? But they're out of Austin?
Yeah.
Thank you. Okay, well, we'll see if they show up to court.
But you just receive information from a third party in a report.
It's what is, what,
That you don't even know who actually does the analysis, but you just receive information.
Guerrera?
Barrera.
Oh. Please come forward. Thank you, ma'am.
Okay.
And have a seat and we'll swear you in. Yeah. And raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you.
Lower your hand. Go ahead.
All right, good morning, Ms. Barrera.
Good morning.
How are you currently employed?
I am the regional manager for RMS in Houston, Texas.
Can you explain what RMS is?
It's Recovery Monitoring Solutions.
Do you provide monitoring for scram bracelets?
Yes.
How do you monitor those?
They are, clients will come in with a referral. They will provide us with the referral. We make sure that we understand the device they need to be on. And they sign a contract and we proceed with installing the equipment or the things monitor.
Now, does RMS provide consistent monitoring on that system the entire time that the client is wearing the bracelet?
Yes.
How does that work?
So can you explain that question?
So the device, how many times does it test the sweat of the individual?
Hold on, we're talking about the scram?
Yes, Your Honor.
Okay, can you tell me a little bit about this, the scram, what the initials stand for, so the record is complete, and how it came into being and how it's used generally?
Your Honor,
Okay.
can I take this person on board now?
Yes, you may. Go ahead.
Good morning.
Good morning.
Before we go into the workings of the scram, I need to ask you some questions, ma'am.
Okay.
What is your educational background? Where did you go to school?
Some college.
Okay, what do you mean some college? Where did you go
I
to?
did about a year in community college.
Okay, it was out in Houston?
Yes.
Okay, and did you receive a degree?
No.
Okay, in reference to the scram, have you ever done any studies in reference to the scram and how it internally works or how it's been put together?
I've had some training through AMS, which is the makers of this.
Okay, and what type of training did you have?
I had training as far as like installing the equipment, reading reports,
Okay.
things like that.
Now, in reference to the internal of the scram and how those reports are generated, do you have any knowledge of the workings of the inside of the scram in order to produce those reports?
So the reporting is received to us from AMS.
Ma'am, my question is, what training and experience have you had in reference to the inner workings of the scram device? In reference to how it takes the sample and how it formulates an opinion. Were you ever involved in anything like that? The internal workings?
Not necessarily.
Okay. You were.
Not necessarily. What does that mean?
So AMS will, well, let me go back. So at the beginning, they will train us on how the bracelet works. But as far as like the internals, all that is done through AMS. They provide the reporting to us and then we provide the reporting to the agency.
So it's safe to say that you were taught how to put the device on an individual, correct?
Correct.
You were taught how to send whatever information you need back to the corporation or the company, correct, for analysis?
Yes.
And then they come back and give you a report.
That's
Is
correct.
that just in simplest ways?
That's correct.
But you don't know how they determine what information is put on that report. And what I mean is the results. You don't have anything to do with that.
No.
You don't have any knowledge whatsoever of how the calculations and the formulas used in order to say, yes, there's a positive or there's a negative in the reporting. Is that fair to say?
It's done for AMS.
You just receive a report from a third individual that you don't even know who actually does the analysis, but you just receive information from a third party in a report.
That's correct.
Mm. And you've never done any writings, research, studies in reference to how this actual, I guess, calculation is done, like the analysis and stuff like that, correct?
Correct.
This time, Your Honor, I am going to object to any type of findings from this witness that she is respectfully not qualified, but if she wants to testify to putting it on and taking it off and submitting the information, we are challenging the actual results of the scram device.
Okay. Any response from the staff?
Your Honor, she's perfectly capable of reading the reports and what she says. I brought her as a custodian of record to get the reports in. That she can tell if the reports are accurate, if they're good reports. She doesn't need to be a member of AMS. She's gone through all of the training. She works with the monitoring business. Just because she doesn't have the actual internal minute workings of the device does not mean that she can't testify to the report or to the fact that she's a custodian of record for the reports to be admitted into evidence.
And that's, if I may reply, Judge, it is the information in the reports that are hearsay. And that she does not, yet she has a report. But it is the person that prepared that report and the analysis that was done for the reliability of the information that was given to her that we object to. Not that she's a custodian or she has a record.
Anything else?
No.
The court is going to refer the parties to State's Exhibit 1 that was admitted on June 6th in this court hearing.
No, it was not admitted.
It's dated that and it's on the record.
It was shown as an exhibit. I made an objection. You sustained my objection.
That's why she's here.
Sir?
That's why she's here today. Is those objections, he objected we didn't have the custodian of the records. We brought her. Today's objection is it's a scientific objection.
It's always been a scientific objection, Judge.
The record will speak for itself what happened on June 6th. I was here, I recall what was said. If we need clarity, we can look back at the record.
Okay. What he seems, Mr. Burbank is objecting to, at least in this hearing, is the methodology of how it works, which is clearly described in this report called State's Exhibit 1. She hasn't testified to any of that. It's all in here. She is testifying to, like a blood draw, how a sample is taken and what happens with the sample to ensure that the sample is a valid sample that can be tested. But the science behind the testing, not the actual engineering of the carrying it out, but the science of how testing is valid and is a science that we can rely on for its results, or really twofold. I mean, the science behind it, somebody has to have information and the ability to say, this is the way it works. And then number two, we took a sample and it was analyzed in a fashion that is accepted by science and is deemed believable by science and history and training based upon proper training if it's carried out right. But those are always the two parts of whether it's blood, urine, breath. Those have always been the bases. It's what testing is theoretically accepted, that is based on a science. And then number two, is the actual application of that theory accepted by courts and experts, carried out in a manner that does not cause the testing procedure to be questioned, or it proves its validity. But he keeps objecting to the theory behind it, which is right here in this exhibit. I believe she's going to testify to
how the theory is applied in a test and where that, how that test works its way through the system. Normal and customary in a way that's acceptable in courts and shows that and proves that it's a valid result. I think that's what she's got is the second part. He's objecting to, she doesn't know how the science works in the first place for it to be accepted. But it's right here in State's Exhibit 1. Is that right?
She doesn't have the knowledge of.
I mean, that's what you're objecting to.
To the theory and the results. And the court did make a good analysis. It's like a blood draw for DWI or an alcohol test result, BAC, that they have to have someone that has knowledge in reference to the testing, in reference to the results that they have in the report. And all she's going to testify to is the results that she was given.
Often the same person takes care of it. It takes care of both issues. He's objecting to what's in State's Exhibit 1.
That is
because he's contending she doesn't have that knowledge that supports.
Judge, it's just today's objection. The last time we were here, he was objecting because we didn't have the person here to support the records.
Well,
we brought the person.
Who was here last time? Was there an individual here?
We could not.
Oh, okay. He's entitled to do it, but he's entitled to object, but he's got a point on it. We've got to have the proving of the science behind it. And then the procedural methodology.
Judge, had Mr. Burbank raised that objection before today,
I understand.
we would.
You're surprised. Okay.
Yes, that's what I'm saying. And frankly, Judge, if I can be honest with the court here, whenever we deal with these, with any individual that's on bond, normally it's about getting the results before you, and we've just been blocked by Mr. Burbank to even let you see the reports. We gave him all the reports that shows not only one violation, but so many violations that instead of just conceding that his client has an issue, the argument today is they don't have the proof about all these violations. That's incredibly frustrating because whenever we deal with people that are on bond and they come in and they have a test in court, Your Honor accepts that.
I understand.
When people have a blood test, you accept that. We have a scram that we've ordered. These are the results. We're trying to tender the results. We can't even get past the point of
I can understand your frustration. Most times the objection like this is not made, but he's representing his client vigorously, like he's required to do in his way. I mean, you can't, I'm not going to say, nope, sorry, you can't object. I'm not going to do that. He's entitled to represent his client, and you're surprised. But you want to, we can put her testimony on while we're here, okay? And the court will end up having to defer unless something happens during this testimony. Defer a finding until, and I will give the state an opportunity to present more evidence to support the record on the way, the theory behind scram and why it is generally accepted as a science. Go ahead.
All right. Are you a custodian of records?
Yes.
How are the scram records kept?
In the course of our business.
How frequently are the reports updated?
They're not so much updated. However, POs will receive a monthly report if there's no violations. If there is a violation, they'll get it within 2 days or so.
I'm gonna show you what has been marked as State's Exhibit number 3. Is this a client report?
Yes.
And does it list all of the days that this individual was running the scram device?
Yes, up until I believe June the 3rd
So that was the last,
Of this year.
this year,
Right.
yes.
so that was the last time that the report was updated for this client.
I believe that's the last time he reported to download the data with an RMS technician.
Okay, so how does that work, the downloading of that?
We have a technician that comes to Beaumont every 2 weeks. I think he is to report every 2 weeks to do download. And that's when we'll get all the data from the bracelet.
Okay, so this report is generated, or the days are generated every time the device is downloaded.
That's correct.
Okay. Now, as part of these readings, does it mention how many times the device does a reading?
It does.
Okay. How many times does a device generally read an individual?
I believe it's between 47 to about 50 readings per day. That's what I've seen.
Do you know why it does that?
Objection, Your Honor. Again, it is not within her scope.
Well, let's find out. It's calls for a yes or no answer. Does it? Then we'll see what the answer is, and then you can object. Go ahead.
Do you know why it does that many readings?
Every 30 minutes, it'll take a reading for alcohol. So it can vary between, like I said, 47 and 50.
Now, besides the number of readings on those dates, what other things does it tell you about every individual day?
It'll have, if there's any alcohol readings, it'll show that as well. I believe that's all that's on the report.
Okay, so it gives positives, does it give tamper alerts?
Yes, it does.
And then does it give equipment alerts?
Yes, it declines to come in for maintenance or to swap out the bracelet or let us.
Okay, so a positive would be the device detecting an amount of alcohol.
That's correct.
What do you know what the lowest amount of alcohol that the device will detect?
Your Honor, yeah, I'm going to object in reference to the.
Let her answer first, and then we'll see where the answer takes us, and then you can object. It's a yes or no answer, then object.
Well,
But
that question wasn't, but okay.
yes, it was. Do you know? Was
What?
No, do you know the lowest amount of alcohol that the device will detect?
I believe that the baseline starts at 0.0008.
Again, Your Honor, I believe.
how do you know that?
I'm drawing a blank, so I'm pretty sure it's 0.0008.
No, but I mean, you didn't just dream that up.
Oh, no.
Okay, I was saying.
It's on the report and it's been it's part of our training. I just don't remember the exact number.
But you do learn in part of your training the lowest number that the device will detect.
Yes, that's true.
Did you also learn as part of your training what it takes to tamper with the device?
Yes.
Okay. How does an individual tamper with one of these devices?
They can place anything in between their ankle monitor and the skin. They can remove it. Anything blocking the device will show as a tamper.
May I have State's Exhibit number 1? showing me would have been marked as state exhibit 1, 2, 3, and 4. Are these records that your company has provided the state?
Yes.
And are all of these records kept in your normal course of business?
Yes.
And are all of these reports made close in time to when the event actually?
Yes.
State exhibit number 1 appears to be a non-compliance report. Is that correct?
Yes.
What is a non-compliance?
A non-compliance report, it's a, confirmed violation. That's the reporting that we send to the PO setting time with a confirmed violation, whether it's a tamper or an alcohol consumption event.
So so you say confirmed, how is it a tamper or a positive confirmed?
Objection, Your Honor. Reference to she's going into how they confirm whether it's been tampered or not with.
Do you know the answer to that?
Yes.
Okay, by your experience and training?
Yes.
Overruled.
AMS has a group of data analysts that will, take a look at all the readings. And they will determine whether it's an actual violation or not. Once it's been confirmed that it is a violation, they'll send a report to us. And then we forward that report to the agencies.
Again, Judge, it's based on hearsay and a third party.
Okay.
That
Anything
you
else?
testify to.
Overruled. Custodian records primarily testifies from hearsay. The key is what is the extent of her training and experience, and this court is allowing her to testify to those matters. Go ahead.
Are you trained in reading the reports that are sent?
Yes.
I'm flipping to page 4 of this report. Does this appear to be a confirmed tamper?
Your Honor. One is she's testifying off a document that I've objected to that is not in evidence.
Sustained. Go ahead.
Well, at this time, Your Honor, state would tender state's exhibit number 1, 3, and 4 under the business records, exception as her being a custodian of record.
Again, I object to states 1, 2, 3, and 4. It is based on
Hold on. What are the exhibits?
States 1, 3, and 4.
1, 3, and 4.
As to the content inside, it is scientific. She does not have the knowledge in reference to how the results are made, and she's just reading off a report.
Okay. Yeah. Anything else?
No, Your Honor.
Overruled. They are admitted. You want to question and attack the science behind it. You're entitled to look into that during cross-examination. But as a custodial witness, this court finds that she has the ability, training from and experience to testify to business records introduction in this matter, and it's admitted. 1, 3, and 4 states exhibits. Go ahead.
Thank you, Your Honor. Back to my original question. On page 4 of state exhibit number 1, does this appear to be a confirmed tamper violation?
Yes.
What does it mean to be a confirmed tamper violation?
That means that, at some point in time, the info monitor, was tampered with, meaning, like I said, it was either something blocking it or, removed that caused the, alert. However, for this particular case, it was tampered with, meaning something was blocking the info monitor.
How are we able to know that?
They'll say confirmed tamper, meaning something was blocking it, or confirmed removal. For this particular case, it's a confirmed tamper.
Okay. And it says that it's a confirmed tamper with alcohol, is that correct?
With traces of alcohol, yes.
So what does that mean?
That although it was
Makes sense.
tampered with, it did pick up some alcohol traces, but the alcohol was not confirmed due to the tamper.
But there was some traces of alcohol detected with the device.
Yes.
Can we see the amount of alcohol that was, that the device detected, even though there was tamper via the TAC value?
We can see it on the graph.
That's,
It's on the graph, but they're not gonna give you an actual percentage because it was tampered with.
here,
But that was the device's reach.
Yes.
And that date was October 29th of 2024.
Yes.
Says that. And then on page 5, this graph, does it show us the amount of times that the device was confirmed to be tampered with via its readings?
Yes.
And then we have a violation on Tuesday, January 28th of 2025, is that correct?
Yes.
Now, what was the violation on this date?
It was, another, tamper.
And was it again a tamper with alcohol detected?
Yes.
what is the bond condition of that tampering falls under? Is it a crime to commit tampering of a scram device?
It's part of his bond conditions, and I'm going to go through his contract where it says that tampering is a violation of the scram device.
Okay, on the bond, you have a bond conditions, thank you.
I don't have the bond conditions. I have his contract with RMS monitoring for his scram device where he signs his initials that he knows that tampering is a violation of the scram device.
It's a violation of law?
The scram device, that it counts as a violation of tampering.
Okay.
And then it appears that we also had a violation on Tuesday, January 21st of 2025, is that correct?
Yes.
And was that, what kind of tamper was that again?
It's a confirmed tamper with alcohol detected.
So again, the device was detecting alcohol, but the device was tampered with, so we're not sure about how much.
Right.
And then we had a violation on Thursday, January 23rd of 2025, is that correct?
Yes.
And what was that? What was that violation?
Confirmed tamper with alcohol detected.
And then it looks like we also had one on Monday, January 20th at 2025, is that correct?
Yes.
Now, what was this one?
Just a confirmed tamper.
So the device didn't detect any alcohol, but we can confirm that the device was tampered.
Correct.
And if we look at the descriptions of the tamper on this date, how many hours does it look like the defendant was tampering with the device?
Over 24 hours, about 2 days.
Is that in a report or something that you have? Does it print out a report that memorializes those suspected tamperings?
Yes, it'll have the timestamp.
May I see? Thanks. Okay. Go ahead.
And again, the device tests over every 30 minutes, is that correct?
Every 30 minutes, yes.
And then we had a confirmed violation on January 16th of 2025, is that correct?
Yes.
And what was this violation?
They confirmed tamper with alcohol detected.
And that tamper began on Thursday, January 26th, and the device did not again return to baseline until Friday, January 17th, is that correct?
Yes.
And then there was another confirmed tamper beginning on January 17th, is that correct?
Yes.
What was that confirmed tamper?
Confirmed tamper with alcohol detected.
Now, that one didn't return to baseline again until January 18th of 2025, is that correct?
Yes.
So what was the confirmed time of that tamper?
About 18 hours.
Let me ask you something too on these reports. What the court has noticed is the reports reflect potential tampers and then also confirmed tampers. So how does that work? Because a potential isn't the word confirmed, it's potential.
Right.
So is it a red flag that alerts the Scram officials to do further analysis to determine a confirmation or not?
Every alert, the AMS analysts have to look at, and they will determine whether it's an actual violation or not. So each and every alert that's generated by the Scram device, they have to look at it and determine whether.
Those initial alerts, are they referred to as potential tamper?
Yes.
Okay, so it's a potential tamper that has to be analyzed
Correct.
fully before it's confirmed.
Correct.
Okay, I never understood that sequence because I'm looking at potential and that's not good enough for me. You know, I want to know how the step went to confirmation.
Right. Like I said, they take a look at each and every one of those alerts, and they have to do their own analysis to determine whether it's an actual confirmation. And if it is confirmed, they'll send a non-compliant report showing that it's a confirmed violation.
I'm trying to use State's exhibit number 3. Does this show all of the potential tampers or the potential positives that the defendant had in the history of having his Scram device?
Yes.
Does it also show how many times he changed out his Scram device?
Yes.
So was he given his first Scram bracelet on April 11th of 2023?
Yes.
When was he given his second Scram bracelet?
February the 6th, 2024.
And then when was his last scrim?
October 29th, 2024.
And through this report, it's 24 pages. Are there several positives that show up in this report?
Yes.
But they're not all confirmed positives, is that correct?
Yes.
So for example, on January 17th of 2024, it looks like he had 16 positives on that date that the device detected.
Yes.
But that is not any of the confirmed reports that we have.
It's not.
So these were not able to be confirmed as actual positives.
That's correct.
But those dates that we have confirmed tampers from January, it does show tamperings and positive results on those dates, is that correct?
Yes.
And since April 10th of 2025, have there been any positives or tampers or equipment alerts on this device?
Since April the 10th?
Yes.
No.
So from April the 10th to 6th to June 3rd, there haven't been any positives or tampers even suspected.
Correct.
I'm showing you what has been marked as case exhibit number 4. Is this the client contract?
Yes.
What does the client contract include?
It has all of the client's information, court PO information. It'll go over the billing, with the monthly billing, the fees, and also the do's and don'ts of the county audits.
And does it include a participant agreement?
Yes.
Does it include all of the things that the defendant is banned from using while wearing this device?
Yes.
What is he banned from using?
He's banned from alcohol consumption, any and all products that contain alcohol, like mouthwash, medicinal alcohol, shampoo, things like that.
So he's not supposed to use any products other than soap and water.
Correct.
And he had to initial there, is that correct?
Yes.
Under tampering, does it say that any use of these banned products or any topical application of a product near the monitoring device in an attempt to tamper with or alter its readings will be considered a violation of this agreement?
Yes.
And did he initial there?
Yes.
Did he also initial that he's not supposed to remove, tamper with, or place any obstructing material between the monitoring device and his leg?
Yes.
I have no further questions, Jerome.
Good morning again. I'm gonna give you these that you testified to, okay, ma'am?
When you're referring to these big exhibits, is that 1, 3, and 4?
Yeah, that have been marked. That states 1, 2, 3, and 4.
I've got states exhibits 1, 3, and 4 admitted, but is there 2 in there?
1, 3, and 4.
1, 3, and 4.
All right, go ahead.
Did you supervise Mr. Raleigh?
I saw him a few times when I came to Beaumont, I think once or twice.
The date that he first got his scram bracelet, what date was that?
That was April the 11th, 2023.
And were you the one that put it on him?
No.
And how often was he supposed to report to your company for testing?
I believe initially every 2 weeks, that's when we come to Beaumont. He's more than welcome to drive to Houston as often as he needs to. But we do come to Beaumont every 2 weeks.
Okay.
I believe that he was given permission to report once a month, if I'm not mistaken.
So how long did he come to your facility every 2 weeks?
I'm not sure because I'm not the person that comes to Beaumont, often.
You were asked to bring the records of Mr. Raleigh. Did you bring those records of how long or how many times he went to your facility to have the scram checked?
I don't know. We have a report that shows how many times he downloaded. But it's not gonna show, what we have here does not show the days that he reported.
Okay, so did he report at least once a month?
I'm not sure because I'm not the person that saw him, so I'm not sure if he was reporting once a month.
Do you know how many times he totally reported to your agency before this date and the date he started?
No.
Well, you had to report sometime because you changed the bracelet out.
Yes.
Why did you change the bracelet out?
I'm not sure.
Okay. Was there a reason? Do they go bad?
So we have a yearly, annual maintenance, what we call annual maintenance, where they have to come in and swap out the device.
Let's stop right there. Tell me why you have to have annual maintenance. Why do you have to have an annual maintenance on the scram?
Where AMS, has asked us to, allow the client to wear the bracelet for 360 days. Then, remove it, they're sent back to AMS for repurposing.
So, okay, so why do they have to do that within 260 days?
Sometimes the clients don't get a brand new bracelet. They may get a bracelet that, has been used prior.
Okay.
So, somebody else may have used it for 100 days before the person got it, installed. So they may only be able to wear it for 260 days.
So how do you know that whether or not, do you have records of whether or not he received a used bracelet or not on any of these occasions?
There is a way to find that out, but I don't believe it's in this reporting.
Okay. And how did AMS decide that within this period of time, they have to bring that unit back to repurpose it? What happens?
We get a notification, stating that it needs to be swapped out.
No. Why did they determine that they had to take that unit off market and repurpose it? What happens to that unit?
It goes back to AMS.
Now, you're missing the point. You don't know why they determined that they have to go back and repurpose it. Like, is there possible problems, or do they have to reboot it, or do they have to clean it out and put new stuff in it to get better readings? Do you actually know why they do that?
I don't know exactly why they do that.
But you have to do that, right?
Yes.
And a lot of times they have used bracelets if it's within that time period.
Yes.
And you don't know whether or not Mr. Raleigh received one of those used bracelets.
I do not know that.
Okay. Now, the other question now is that if you had all these violations or potential violations, was Mr. Raleigh ever apprised that, hey, you've got some problems, with this, bracelet, you're coming up positive? Do you know if he was told?
I have no idea.
Well, you have a lot of violations before April or May or whatever it is that we're here today. Do you know whether or not he was ever advised that this is a problem and you're violating or tampering the scram?
I personally never spoke with him about that, and I don't know if he spoke to anybody from RMS in regards to that.
When you say that it detected alcohol, do you know what type of alcohol it detected?
It's I believe it's I can't think of the word.
Let me ask you this, how many types of alcohol are there?
There's breath alcohol
Huh?
and breath alcohol.
No, I'm talking about consumption alcohol, because you're not saying that this unit detects breath. Does it?
not.
No, it does not. And how does this what does this unit detect?
It detects alcohol that basically comes out through the skin.
Okay, evaporation.
Right.
Okay, so what types of alcohol comes through, or is the ethanol, alcohol? What types actually come through the skin? You don't know, do you? Do you know how many products contain alcohol or ethanol that could be detected in the world today?
A lot of
A lot. I mean, almost a lot of things have it, right?
right.
Do you know where those samples, what it actually detected?
I do not.
What are some of the things that you know of that possibly, you said mouthwash was one, right? Correct?
Correct.
Toothpaste?
Correct.
So that's hygiene. How about any type of soap?
If it has alcohol in it, yes, it would.
Okay, how about lotions? Okay, mosquito repellent.
I've never looked at the back.
Yeah, right. But it could, right? So you don't know how it differentiates between, or does it just, the different alcohols? Or does it just pick up any type of alcohol or detection?
It'll pick up any type of alcohol.
Any type of at all? You're not saying that he consumed alcohol in these tests?
That's not what the reporting says. The reporting says tampers.
Okay. Now, how did he tamper with it?
We don't know that.
Well, in states, whatever you have there, you testified that, for instance, well, strike that. In a couple of things that you testified to, you said that tampering went on for 24 hours or more. The other one was 18 hours. Remember testifying to that?
Yes.
How does someone tamper that long with your device?
So in order for it to be a tamper, it has to be blocked. So something has to be blocking the skin and between the skin and the ankle monitor. What device they use or what they use, we're unable to determine that.
On the days you testified, was he ever, do you, in your reports, indicate that Mr. Raleigh was notified of what were you doing over that 24 hours or 18 hours or 30 hours to tamper with this device?
Can you repeat that one time?
Yeah, I mean, did anyone from your company say or notify him, why do we have a tampering for 24 or 30 hours or 18 hours? What were you doing with this device?
Our corporate office, they will contact the client if needed.
Okay,
That's only if it's been requested by AMS.
okay.
They will,
Hold on a minute, because we gotta get, do you have anything in the records that anyone contacted Mr. Raleigh?
not sure.
Do you have anything that says that AMS contacted your company or Mr. Raleigh to determine what was going on?
AMS does not contact the client.
Okay, did the AMS contact you through
I'm
your?
not sure.
Okay. Because this is over a period of time where you're saying it's either positive or false or potential. Is that what it is, tampering? Is that what you were saying?
For this particular case, it's, they're all been confirmed.
Well, you just testified that there were possible potential and not confirmed. You remember
Oh,
testifying?
yes, yes.
But in all these cases, do you have anything in your records that says that AMS contacted you or you contacted the client saying, what's going on? What are you doing with this scram unit?
I think I provided the notes, the client's notes, but it's not here. So if I had a copy of that, I could go through the client's notes to see.
I would really like that because I don't think I was provided with that either, ma'am. Where did you provide those notes at?
I think it was sent to, okay, I'm sorry then.
Where are the client's notes?
We have copies of the notes. I can go into his account, print them out and provide them.
They're readable for? Okay.
Yes.
Subject to that, Your Honor, I'd ask for a short recess or something so I can get those notes. I'd like to
What do you mean
know,
short recess?
huh?
What do you mean short recess?
Just to get those notes so I can look at them. I think they're important as to the.
Oh, okay. Yeah. It would you be, so can we help her get to a phone or something to get those?
She need a computer?
Oh, okay. Would you be so kind?
Yeah.
Thank you. We're in short recess.
She may need to get printed out somewhere.
She can send it to me. She has my email and I'll print it out.
All right, we're in a short recess while we get those records, about 10, 15 minutes, maybe. All right. And I just move on, you know.
Client reports, is that? Maybe one,
Well, yeah.
or you only need one.
Go ahead.
Show you what has been marked as defendant's exhibit number 1. Do you recognize that, ma'am?
It's,
And I want you to testify to some of that, but briefly, you said these are client reports, is that correct?
yes, it's a report of the note.
Okay. And again, you don't know the workings in reference to how the information is generated in that report and their final, I guess, information. But you are the custodian of the records, and this is the client reports of Daniel Raleigh, correct?
It's a client report of the notes.
Okay.
Yes.
And you don't know if there's any information that was generated by the home office. You don't know how that was even generated, but this is an actual report.
It'll just have all the notes. So for example, let's say the client calls in, we'll put a note in the system, this is what this is. Or if somebody from AMS wants to add a note into their account, it'll be saved on here. Or if our corporate office will contact the client, they can also add it. So this is just notes.
So it fairly inaccurately depicts what yes, what it is, right? I mean, you don't see any deletions or any modifications in that, correct?
What do you mean by that?
Well, is it true and accurate?
Yes.
No one's not being an oxymoron, tampered with it?
Tampered with what?
These notes?
No.
Okay, subject, I tend to defendants one, Judge.
The objection?
Without objection, Your Honor.
Admitted.
Let's go to page 1 of 33, okay? It says critical communications. It starts off with call client, downloads. What is that about? Do you know?
On what date?
Well, it's first page, page 1, which would have been April 23. We're going to move real fast on this.
I don't have April 23, I have April 24th.
April 24th of 2023.
Okay, what time?
Well, it's on page 1. And Yolanda Martinez.
Okay, critical communications. Date received 4/9/23.
Yeah, but what is it called client? What does that mean?
Call client who stated he was told monthly downloads by RMS technician at Beaumont. After taking client's NIPS account, and note states monthly downloads per field tech Nick at Beaumont.
Okay, so you have to download something. There was a problem with the download?
No, that means that, I believe at some point, the client was granted permission to report to the Beaumont office once per month to download his data.
Okay, so he downloads the data himself, or is there somebody in the company?
The technician.
Okay, and then if you go to page 2, in July of 23, why does he have to replace the battery so soon? July 13th of 2023.
Replace battery, that means that, every 3 months, we have to replace the battery. That's just, regular maintenance that we do every 3 months.
Okay,
So he was just due for a new battery.
remove the bracelet, wipe kit, clean battery contacts, wipe and clean the microfiber, using microfiber and cloth, install new battery and faceplate. Normal?
Yes,
And that was done that day, correct?
yes.
Then the next day, you had him come back and do the same thing again, didn't you?
Oh, no, I'm sorry. This is just, a note that Gabrielle Dunn, out of our corporate office put in stating that he needs to report for a battery and, the instructions on what to do when he reports.
Okay, and he did report, right?
He reported on, July the 18th, 2023.
Okay, and you did that.
That was done by the technician Nick out in Beaumont.
Okay. And then in September and October, there's critical communications on page 2. What is that?
That means that we haven't received any data from the bracelet for a period of time. But he's gonna have a lot of those because he was granted permission to report, to download once a month.
Okay.
So after a couple of days, they'll get a critical communication alert, meaning that they need to report to do their downloads.
And then I guess there was another battery change in October of 23.
It looks like he had a battery, replaced battery alert that generated in October. And, I'm not sure when, yeah. Okay, so it looks like he reported, November the 2nd to have the battery replaced.
Okay, and that was every 3 months you have to have a battery replaced,
That's correct.
and he did that. Right?
Yes.
And I guess there was no problems up until that time that you were aware of? I didn't see anything that says we were receiving any false positives or positive that you were tampering or anything else with that. We agreed?
Yeah, prior to that, there's no notes.
Okay, now January 1st of 24, client,
24 or 20,
January 24th of 24, which is on page 4. Called client regarding a bracelet replacement. Why would he have to have his bracelet replaced?
that means that it was just, time to replace the bracelet.
Okay, and did he do that?
So he reported, February 6th, 24, and that's when he got another bracelet, yeah.
Another bracelet. And then there, on page 5, there's a number of things, or a number of times that says having problem contacting or making, or something, the bracelet has not made contact with the network. What does that mean?
That he's not downloading, but again, it's because he reports to the Beaumont office to download.
Okay,
So
so,
it just means that the bracelet hasn't contacted the network in over a period of time.
okay. And then he had scheduled maintenance again in May of 24, is that correct? That's on page 5.
Yeah, he had a battery replacement on May the 7th.
And then, in August of 24, he downloaded again, I guess, right? Page 5 on the bottom. Client will meet Nick. I guess it was August 13th.
Yeah, that's just a note that they put it in that he was going to meet it, the guy.
Okay.
I don't know, yes.
Now, maintenance was performed on August 13th, correct?
Yeah, no, the battery replacement.
Okay, and then if you go to page 6, it says on August 13th of 24, confirmed obstruction from August 10th at 8 a.m. to August 11th at 6:30 p.m. What is that?
You're on page 6?
I'm on page 6,
At the
right
top
at the
of the
top. Yep.
I have start 8/10/24, 5:08.
Right. That's what I said.
8/11/24.
To 6:30 p.m. Right?
Yes, that's correct.
Okay. Where did that come from?
That comes from, once, AMS will confirm, the data or the alerts, they'll send that or they'll include that into the client's, account. And our, technicians in our corporate office, they'll look at that and put that note in.
Now, question is where did that come from?
What came from what?
Well, where did that is tampering confirmed?
Oh, that comes from AMS.
Oh, yeah, but what, did it come from the old bracelet or did it come from the new one?
So that would come from bracelet, that comes from his second bracelet.
So that's the new one.
Right.
Okay, well, he just put that on that day.
He didn't put it on that day. That the obstruction is from,
Scheduled maintenance was performed, battery and faceplate replaced August 13th, 2024 at 1:30 PM.
yeah, that's just a battery. We don't swap out the bracelet when we do batteries. So that scheduled maintenance is just a battery.
Okay. And then it came back in September. Client came in, downloaded all the meetings, right?
Yes.
And you scheduled a equipment replacement for October 29th of 24. Right?
Yes.
And did he do that?
Yes, he reported on, October the 29th, 24, for our new bracelet.
Yeah. Did he have his bracelet replaced
On what date?
somewhere around October?
Yes,
Okay.
he had it replaced, October the 29th.
On page 6, you got page 6, ma'am?
Yes.
It says potential tamper. January 16th of 25. 1:12 PM.
Correct.
Says fit check is required. What is a fit check?
We need to make sure that it's not too loose or too tight.
Adjust bracelet and ensure proper fit at lowest part of ankle. Correct?
Correct.
And then connect bracelet to complete reinitialization process. What is that?
So it basically means, we have to find a baseline. The IR has to have a baseline. That's what it is.
So they didn't have a baseline before January 16th of
It
25.
does, but every time you remove it to do a fit check, you have to, do a new baseline.
Okay, so you had to remove it at that day?
Yes. Mhm.
Okay,
You have to, pretty much undo the straps, tighten it, make sure that it's a good fit.
and when you did that in January of 25, okay, you said you informed him that his bracelet was in need of maintenance, and when could he come back to the office? Right?
What date are you looking at?
January 16th of 2025. Under potential tampering, you knew that there was a potential tampering. I think you testified to it. And you told him that the bracelet needed maintenance.
Yes, called and informed him that his bracelet was in need of maintenance, asked when he would be able to go back into the office. Client says that he is in the middle of nowhere at the moment and doesn't drive. He would have to get a ride and isn't scheduled until his next down.
Okay. And then what happened if you go to the next page in February 6th, what happened after that? There's another potential tampering. Fit check is required. It's on page 7.
Fit check is required. First, use maintenance link on client's equipment tab. Second, adjust bracelet and ensure proper fit at lowest part of the ankle.
Right.
Finally, direct connect bracelet, last complete reinstallation process, transfer alert to AMS.
Battery needs to be replaced.
Battery needs to be replaced, battery faceplate.
Okay. Provide kit wipe or fine brush or spray with yellow Windex. What is that all about?
It's just part of the process when doing batteries. And anytime that we take a battery out and put a new one in, we make sure that the area is cleaned before putting the new battery in.
And you told him that his next maintenance date was February 11th of 25, correct? And he showed up
He showed up on
February 11th of
February the 11th.
25. So you told him when it was and he showed up.
Yes.
Okay. Now on February 11th again, you didn't replace the bracelet, right?
No,
Okay. It showed obstruction. It showed tampering. All these things. And I'm on page 8, right?
yes.
So what happened?
This is just to note that the potential tampers were analyzed by AMS and confirmed. And once they're confirmed, they were provided to us. Then we provided that to the agency. So this is just a note of that, stating that they were confirmed tampers.
And this is all the time in which you're replacing batteries and wiping it down and cleaning it and doing whatever it is, right?
I'm sorry, say that one more time.
This is during the period of time that we just talked about, that you were wiping it down with Windex and redoing the batteries and doing whatever the maintenance was, right?
Yes.
Okay. Alcohol detected. Let's go to the bottom of February 12th of 2024. Not confirmed as consumption. Environmental alcohol contaminant present. See that?
Yes.
What is that?
It's just a note indicating that alcohol was detected, but not confirmed.
So there again, when you did see, it doesn't tell you what type of alcohol, whether it's consumption or not, but somewhere he has come into contact, or his skin or the evaporation has come into contact with alcohol.
Correct.
But you don't know what the source is.
No.
Called client about the violations. He agreed to be more careful, stated he retired, doesn't know what could cause it. Is that right? And that's February, right? Of February 12th? At the very bottom
25.
Yeah. He agreed to.
of 25. Page 8.
Yeah, called client about violations. He agreed to be more careful and stated he retired and doesn't know what could cause.
Let's go to page 9. You have alcohol detected, confirmed, detected. Again, not confirmed as consumption, environmental alcohol contaminant present.
Correct.
Called the client, reminded them to refrain from using alcohol containing products, right?
Right.
They think it might have been a spray they had started using, or will refrain from using it going forward. What type of spray did he say?
Doesn't say.
Okay. And when it says critical communication, that is, you're just waiting for him to come in and download it. So that's because he's on a monthly reporting, and they want it like every 2 weeks.
Yes.
The last date I have of his notes is June 18th of this year, 25. Correct?
Correct. He's due for a battery.
It appears that Mr. Raleigh has been compliant with all your company's requests, except for the alerts that you've received. He's come in, what I mean by that is he's come in on time, correct? On the date he's scheduled.
Yes, I believe so.
He's abided by whatever the replacements or whatever, when you communicate with him, you've gotten a hold of him, right?
Yes.
And told him what he needed to do, and he's been obedient with that.
Yes.
Correct. Okay. Do you realize that he doesn't live in Beaumont? He lives up in East Texas, kind of away from here. I know you're from Houston, but from not around here.
I think he mentioned that to me one time.
Okay, I think it was Evendale or somewhere around there that he lives. You don't know where. I bet you've never been to Evendale. Okay. But he's been compliant and any concerns, he's tried to address them with you, correct?
Yes.
Subject to recall, Your Honor, I pass the witness.
Anything else, State?
Yes, Your Honor.
Go ahead.
If you look at Defense Exhibit 1 at page 6, there was a confirmed tamper on August 13th of 2024. Is that correct?
Which one are we looking at?
Defense Exhibit 1, the one that you were just looking at.
Okay.
Page 6.
Okay. Okay.
And that date, August 13th, or I'm sorry, I guess the violation started August 10th and ended August 11th. He had a confirmed obstruction with alcohol detected. Is that correct?
Yes.
Now that was confirmed after he had come in from his scheduled maintenance. Is that right?
Yes.
So the obstruction would have been several days before his scheduled maintenance if it started on August 10th and ended August 11th.
Yes.
It was confirmed in what manner, method?
Like I said, AMS, they confirmed, the data and sent it to us. I guess I'm not understanding the question.
How is it, yeah, what is used to confirm? Is another test given or is?
They look at the temperature, they look at the IR, which is the baseline that the bracelet has initially when they come in and get it put on. So anything outside of the baseline readings and the temperature, will determine whether it's confirmed or not.
They're reviewing the original alert. Is that what you're saying? They're not doing a separate test.
Oh, no, they're
confirm.
reviewing the original.
You know, like taking another specimen or sample of the man. They are taking the data from the original alert and then retesting it to determine accuracy.
That's correct.
Okay.
And they sent you a report for that date confirming the tamper, right? Is that
Yes.
correct? And then on January 16th, the defendant was called and informed that he needed to come in for maintenance because there was a potential tamper and he needed a fit check.
Correct.
What was the date that he actually came in for that fit check?
He came in on, February the 11th.
So almost a month after being told that there was an issue, he finally came in and got that fit check for his regular scheduled maintenance.
Yes.
So he didn't comply with what your office had requested of him.
It took him about a month, but eventually he complied.
And when you did do the download, finally in February, you received several confirmed tampers. Is that correct?
Yes.
And just so we're clear on the record, the dates of those confirmed tampers were January 16th, January 17th, January 19th, January 21st, January 23rd, and January 28th of 2025. Is that correct?
Yes.
And then on March 25th of 2025, did you receive information that there was a confirmed obstruction on February 27th of 2025?
Yes,
And was there also alcohol detected during that time?
yes,
And that was after he had come in for his fit check and his scheduled maintenance.
yes.
Now, based off of the reporting from March 26th and March 27th, there is the ability to tell when there's environmental alcohol and it's not alcohol consumption by the defendant. Is that correct?
Yes.
So they were able to confirm that on those dates, it wasn't alcohol consumption and the device hadn't been tampered with. And he was called and told not to use any banned products or anything with alcohol in it, correct?
Correct.
So those dates are not part of the confirmed tampers that we have in front of us, is it?
No, because they're not confirmed consumptions.
I have no further questions, Your Honor.
Can you listen to the court, what the state contends are the confirmed tampering dates?
August 10th of 2024,
Stand by. Okay,
January 16th of 2025, January 17th of 2025, January 19th of 2025, January 21st of 2025, January 23rd of 2025, January 28th of 2025, and February 27th of 2025.
eight separate events. Am I adding that up right?
Yes, and there were 2 events on January 23rd of 2025, so it'd be 9.
Say it again.
There were 2 events on January 23rd of 2025, so it'd be 9 events. But 8
I'm a little
dates.
fussy about the 2 events. What are the 2 events again?
2 different tampers, same day.
2 different confirmed tamperings, but on the same.
Now, are all of these? Okay, what's the difference here on the dates for tampering and positive readings?
So all of them but one are confirmed tamperings with alcohol detected. Now, we don't know how much alcohol there actually was because of the tampering, but they're tamperings with alcohol detected. One of them is just a tampering, so no alcohol was detected, but it was a confirmed tampering with the device.
Out of the 8 dates here, is that right?
Yes.
Defense.
2 questions, ma'am. Maybe more. You don't know what type of alcohol was in the system, correct? Where it
Correct.
came from? And you acknowledge that besides an alcoholic beverage, other products do have alcohol
Correct.
that could be detected by your unit.
Yes.
And you can't determine that, or you don't have the qualifications to determine that today, is that correct? Whether there's a difference. You're not a researcher, all you have is a report, correct?
Right, we won't know which type of alcohol it is, correct?
That's right. And number 2 is there was an inference that when you notified him in February of 25, it took him over a month or a couple of weeks to get to your facility. So anything that he was trying to avoid you, that's the implication that the state was trying to get to. Did he ever refuse to come in from your notes?
No,
Do you have regular monthly or bi-weekly appointments at your company?
yes.
Is there any indication that he ever missed any of those appointments?
I wouldn't be able to tell you that based on what I have.
No, the notes are there.
Right.
All right, is there anything in your notes that says that?
No, that never showed up.
Yeah, he never showed
No,
up.
it's not in
Every time he was scheduled to be there, he was there, correct?
It wasn't immediately, but he eventually reported.
Then show me, can you show me in the notes where you requested him immediately to show up at that office?
On several of the notes, it does state that, he's to report, whenever the next time he's in Beaumont, but I don't have a log to show how many times Nick was in Beaumont to see if he actually reported.
Is there anything in the notes that says he was told to report immediately to our facility because we have a problem?
I don't think so.
No, there's nothing in that. And that it does reference that, make sure you make your maintenance appointment or your download appointment, right? In which he complied with.
Yes.
Pass the witness.
No further questions, John.
Let me just get a couple of things clear. Because just when it seems clear, then it gets fuzzy. Is it your contention that the testimony of this witness is when it shows a positive reading of alcohol, there's no way we can tell if that's isopropyl alcohol, alcohol from medicinal versus bourbon? Is that what you're saying?
That's the great unknown, Judge.
No, is that what you're saying?
That's the reason why I objected to her testimony, because I think we need the individual that does the testing, that is part of the AMS or whatever it is, that's part of the evaluation of how it works to determine what it's actually detecting.
Go ahead. What state say to that?
Your Honor, she's already testified that they can tell if it's environmental. They called him several times with non-confirmed alcohol consumption because they could tell that it was environmental alcohol consumption, and there wasn't a tamper with the device. On the occasions that we have confirmed tamperings, it was with alcohol detected and the device had been tampered with, and it was confirmed via the reports. Now, we don't know what the alcohol was or how much there was because of the tamper, but we can tell that there was something done by the defendant to the device.
That wasn't the question you asked, Judge.
I thought at the end, he asked her a question that she that refutes that she couldn't tell that you can't tell the difference.
Right. And that was in reference to
That's what
consumption.
was said a few
because
moments
there's
ago.
other products I'm sorry, Judge. There's other products you can consume. She's talking about something about a spray or a lotion or something that's outside the consumption. But I'm talking about being able to detect what it possibly is in reference to the consumption or consumed alcohol they're saying that he did.
What about the tampering allegations? Go ahead.
I mean, again, what is the basis? How do they determine a tampering? I mean, she just has a report that says it's possibly tampering. And what I understood out of the 8 or 9.
That's not what, it says possible, and then I'm reading possible and confirmed are both used here. There's a big difference. But you said possible, I'm seeing confirmed also in these reports. What about that?
Well, again, what is the basis for that? How is that tampered with? And how is it tampered with by a person that has done the research and the evaluation? She's just the custodian of the records.
Any response from Staten? All right, here's the way I'm looking at this. This is the first impression for me out of all these years, because we get either it's clear that there's alcohol or not alcohol. And the way to drug screen, we're talking about breathalyzer. It says breathalyzer slash alcohol and then percentage of alcohol. Well, obviously, what we don't want is alcohol consumption that leads to intoxication, whatever that might include. The other issue we have is the tampering issues. And one of the first bond conditions always include number one, don't commit a crime. And tampering with or fabricating physical evidence is what we're talking about right here under section 37.09 of the Texas Penal Code. Person commits an offense if knowing that an investigation or official proceeding is pending or in progress, and it's pretty clear he knows he's under indictment and he's got bond conditions. That fits that condition. He alters, destroys, or conceals any record, document, or thing with intent to impair its verity, legibility, or availability as evidence in the investigation or the official proceeding. And I think you can read this clearly to apply to taking of specimens. If you attempt to tamper with the device that is ordered as a condition of bond to have either urine or a specimen of some sort of the person, whether it's urine or breath in this case, and in some way it impairs its ability to be provable and accurate as evidence in an investigation or official proceeding. And that's what we're talking about here, an official proceeding or of a bond matter, then that is a crime, which is a violation of condition 1 of a bond condition, or makes, presents, or uses any record, document, or thing with knowledge of its falsity and with intent to affect the course or outcome of the investigation or official proceeding. And that's available as well as a method of revoking a bond if it is proven by preponderance of the evidence or greater that the person has tampered with the device in some way. And nothing in this statute explains how it's going to be tampered with, just that it gets tampered with. She doesn't have to prove the method of how it's being done. There could be a myriad, countless methods of attempting to falsify or obstruct the device from working properly to get the specimen. Show me under the statute where it says that's a problem. It doesn't. It's the product.
The problem though, Judge, is that you have the custodian of the record based on a scientific equipment and analysis. She is not.
You want to call somebody?
She's not the
right. Do you want to call somebody?
It's the state's burden.
I know. I think it's the state's met its burden by preponderance of the evidence or greater. What do you want to do next?
I'm calling my client to the stand, Judge.
Okay. Your excuse me. Thank you. Go ahead. Go ahead.
Let her get her stuff first.
Take your stand. Take a stand. Raise your right hand. You solemnly swear or affirm this testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Lower your hand. Go ahead. Sit down, please. Thank you.
Please, court.
Go ahead.
For the record, could you state your name, please? Daniel Clayton Rowe. And Daniel, you were under the bond conditions in reference to have a scram device, is that correct?
Yes, sir.
And were you compliant with that?
Yes, sir.
How many times have you gone to AMS or whoever the company may be in order to do what they said, like download or replace?
I go once a month, sir.
Once a month. Did you ever go twice a month? Every 2 weeks? Do you know?
I don't think so, sir.
Okay, so you go once a month. And could you tell at any time, did they ever tell you that you were tampering with the bracelet?
Nick never said anything
Right?
about that.
Did they voice concerns in reference that sometimes it wasn't adjusted right or things that were being done?
No, sir.
Did they ever say that you were testing positive for alcohol?
No, sir.
Since being placed on bond, have you consumed alcohol?
No, sir.
There was something in the notes that said something about a spray that you all were using. What was that about?
I think it might have been some deep woods off, sir.
The what?
Deep woods off
Deep woods off.
with mosquito was home.
Okay. Where do you live?
Up near Burkeville.
Okay. Out in the woods?
Yes, sir.
Okay. And did they indicate anything about that or to possibly not use it?
I got a call on the phone telling me there was an environmental problem and stop bringing whatever it was, whatever I was using.
Okay. Did they ever call you and tell you that it was detecting that you were consuming alcohol?
No,
And you haven't consumed alcohol?
I have not.
And you've been compliant with everything?
Yes, sir.
Have you tested, you've had drug tests here, correct?
Yes, sir.
Okay. And that's with this court.
Yes, sir.
Are you driving?
No, sir.
Have you driven since being placed on the conditions of this accident?
No, sir.
Do you even have a vehicle?
No, sir.
And who do you rely upon?
My sister.
And she's been with you the whole time and back and forth and stuff like that.
Yes.
You don't live with her, do you?
I live off the next door,
The same property?
same property.
Okay. Pass the witness, Judge.
You were notified on January 16th that they wanted you to come in so that they could check your device. Is that correct? January 16th of 2025. And you did not come back until February 11th of 2025.
I came in every month they appoint.
But when they told you that they wanted to check out your device, you did not come in until 3 weeks later. Is that correct?
I asked them if it was okay.
Is it yes or no? Yes or no, and you can explain. Yes or no, sir, and then you
No.
can explain your answer.
So they didn't call you on January 16th to come in for a fit check.
Yes, they did.
And you showed up on February 11th. Is that correct?
Yes, ma'am.
Because you told them you're in the middle of nowhere at the moment and you don't drive and you have to get a ride and isn't scheduled into your next download. Not that they told you it was okay, but that you just weren't. Is that correct?
I recall the phone conversation, ma'am. They said that would be fine.
But during that time that you didn't come in for 3 weeks, you had all of these potential tampers. Is that correct?
I don't know, ma'am. They didn't tell me.
Are they required to tell you?
They never have.
Right, because they're not required to tell you, right? They don't have to tell you that you're committing a crime, that you're violating your bond, that you're messing with the device, are they? They're required to tell the court, right?
I asked Nick.
But he's not required to tell you anything, is he? Are you aware that since I filed my motion to revoke your bond, that you've had 0 issues, not even a potential alcohol use or tamper since I filed my motion? Are you aware of that?
Trying to be extra careful.
But you weren't extra careful in the other times that you tampered with your device?
I did. I didn't tamper with the thing. The only thing I'm aware of that I did was maybe use my sister's shampoo and some deep wood salt.
I have no further questions, John.
Daniel, you would hope that if something was going wrong, they would have told you, hey, we have a problem here, right?
I would tell my sister and we would have dealt with it immediately.
Okay. And when you went and talked to, was it Nick that you always went to see with the scram?
Yes, sir. Next time in.
And he's the one that would come over from Houston?
Yes, sir.
And you would have hoped, though he didn't have an obligation to do it, that he would tell you if there was a problem, right?
When we started out, I'd ask him if everything looked okay, and he'd say, yeah, and I quit asking after a while.
Okay. And so you would have thought that he would have said something to you.
Yes, sir.
Okay, but there was never any indication.
Not that I'm aware of, no, sir.
And still, you have not consumed any alcohol in violation of this order.
I have not.
Anything else?
Nothing. That's
All right, have a seat.
I call his sister, Your Honor.
Come forward. There.
Just so everybody knows, I'm part
Have
of
a seat.
yeah.
Have a seat.
So I
please.
do have to.
Thank you. Raise your right hand. Do you solemnly swear or affirm any statements or testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Go in.
For the record, can you state your name?
Diana by Raleigh?
And Diana, you the sister of Daniel?
Yes,
And do you live on the same property as Daniel?
yes.
Was he living on the same property at the time of this incident?
The incident being
The indictment where he got into the motor vehicle accident?
October 29th, 2022.
we were in the process of moving there, so I was there, he was moving my stuff.
Okay, so after that, he moved in,
Yes, sir.
okay? Do you know that he had a condition that he had to have a scram bracelet on?
Yes,
And did you know that he had a condition that he was not to consume alcohol?
yes,
And do you have daily, I guess, contact with him, seeing he's on the same property?
yes.
Okay. First question is then, did you ever see him operate a motor vehicle, since, this incident?
No,
Are you the one that drives him around?
Yes,
Have you ever seen him consume any alcohol? Have you been in his place or residence or where he stays?
yes,
Have you ever seen any bottles or any indication, beer cans, bottles of any alcoholic beverage around his place?
no,
Have you seen him intoxicated
no,
at any time after this?
no,
And he's complied, to the best of your knowledge, he's complied with all the rules and regulations in reference to staying out pending court.
yes.
Has he ever tried to avoid or indicate to you he's trying to avoid going to the Scram place to download anything or to talk to them?
No, and I've talked to the Scram people myself and tried to get information when they first told us the hearing was coming up. And they told us that they could not discuss with us or send us or notify us of any problems or reports with it.
So you tried to address or try to find out what was going on once you realized he had come back to court.
Yes.
Pass the witness.
I have no question, Chairman.
Okay, you may take your seat then. Next.
We rest.
Fine. Go ahead. What do y'all want?
Your Honor, based off all of these tamperings from August through February of this year, we're asking that his bond be increased. Clearly, it's not enough to keep him from tampering with his device. We don't believe that he should have the current bond that he has. Clearly, this RAM isn't working.
Go ahead.
Your Honor, again, I renew my objections in reference to trying to get someone from the facility to interpret, not just a report. He has tested negative every time he's been here. He has complied, as our contention has complied with all the rules and regulations set out by this court pending his court in August, court date of August 11th. He has come every time. There's been nothing that says that he didn't come in when he was supposed to. And I ask that you continue him on bond and so can be ready August 11th for court.
Anything else?
Okay.
Okay. Everybody agreed the last event that we're talking about here is February 27th. So since then, we haven't had any problems.
He's had potentials, but he hasn't had anything confirmed.
And potential doesn't make it. It's confirmed, whatever confirmed is. So that's March, April, May, June. Now we're in the 5th month of this, but he's had a steady green light, as it were, on his proceedings. Fine. I'm going to hold open the motion. I'm not going to revoke his bond under these circumstances. But the next positive thing, anything we get a positive confirmed, let me know and we'll rush in here, try to get to the bottom of it. Can everybody be ready for trial here in a month?
I'm ready.
Thanks. We're going to try to get that one, unless there's something else that's on fire that needs to get taken care of. But this one has delayed for over 2 years, going on 2.5 years. So we need to move this one forward. All right, anything else?
Not from the defense.
All right. We're in recess. Thank you.
This module comes back on convocation.
That's
Mr. Rayford, can you turn on your camera? We'll call your case in just a second.
Okay, I just turned it on.
All right, thank you. All right, Amy, tell me when you're ready. All right, this is, all right, 212875 and 240622, the People versus Deshauna Rayford.
Good morning, Your Honor. James Gazicki on behalf of Ms. Rayford. A waive reading of the complaint, stand mute, request the court set the bench warrant aside. She's going to plead to a fail to display. The no proof of insurance will be dismissed. And she has default tickets in the amount of $1,124, Your Honor.
Okay. Ma'am, did you understand everything your attorney just said?
Yes.
All right, so you have the one case, these are all warrant cases, so I'll set aside the warrant and then we need to come up with a payment plan so you don't have to keep coming back on this, okay?
Okay.
All right, so on this new case though, from 2024, there's a plea agreement that you would plead to failing to display a valid license, is that correct?
Yes.
You understand that it's a misdemeanor punishable by up to 90 days in jail and a fine of up to $100 plus court costs and statutory fees?
Yes.
Ms. Rayford, did you go over your constitutional rights outlined on this advice of rights form?
Yes.
Did you understand your rights?
Yes.
And did you give your attorney permission to sign your name on this form?
Yes.
Ma'am, you understand if you enter a plea of guilty, you'll be waiving the trial rights listed on this form. There will be no trial of any kind.
Okay.
Well, do you understand that if you enter a plea of guilty, we wouldn't have a jury trial? You understand that?
What is the jury? Okay, yes.
What do you mean? What is a jury trial? So you have a constitutional right to be tried by a judge or a jury on this case. So if you wanted a jury trial, you wouldn't enter a plea of guilty because the determination of guilt would be made by a jury, not an admission. You understand?
Yes.
Okay. And you understand if you're currently on probation or parole and you enter a plea of guilty, it's going to be it could be a violation of your conditions.
Oh, yes. I'm not on probation or parole.
Okay, Ms. Rayford, I don't know if you are or aren't. I have to tell you these things.
Okay.
And you understand, ma'am, that if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation.
Yes.
Knowing all of that, ma'am, how do you plead to the amended charge of failing to display a valid license?
Guilty.
Has anyone forced you to get you to plea?
No.
Has anyone promised you anything other than the plea agreement to get you to plea?
No.
Are you pleading guilty of your own free will?
Yes.
Ma'am, were you operating a motor vehicle in the city of Taylor on March 10th of 24?
I don't recall.
Well, if the ticket indicated that that was the day that you were stopped by police, would you dispute it?
Yes.
So you don't think that's the day you were stopped?
On March 24th? I mean, in 2024, that was last year. I'm not
March
sure.
10th. March 10th of 24 is the day the ticket was issued.
Okay.
Does that sound right to you?
Yes.
Do you remember being in Taylor and getting stopped by a police officer for some sort of ticketable offense?
Yes.
Did the officer ask you to produce a valid license?
Yes.
Did you fail to do so?
I wasn't, yeah. Let me just say yes.
Was your license not valid at that time?
No.
Mr. Gazicki, are you satisfied with the factual basis?
Yes, Your Honor.
All right, I'll accept the plea as knowing and voluntarily given. Ma'am, you have $100 fine, $100 court cost, crime victims' rights fee is 75, and state assessment of 50. Those are mandated by the state of Michigan, those last two, and that brings your total to $325 on this new file. I've dismissed the civil infraction per the plea agreement. And then on the other case, so now you've got this $325 plus the $1,124. And do you need a payment plan on this?
Yes.
How much can you pay a month?
100.
All right, you have a payment plan of $100 a month, and all of it will go together. Ma'am, if you're going to be late on a payment or you don't have the full amount, make sure you call the court and let us know so you don't end up with a bench warrant or a show cause. Okay?
Okay.
All right, you're all set.
Thank you.
Give me a second, I have to catch some of these up. All right, Mr. Bartlett. I don't see your client with us here today, but the prosecutor came on record this morning and dismissed the case against your client. Just for the record, this is on Toddy Poupard. This is the entire case, including the civil infractions, 240-136. They did locate that plea form. In this case, there was a stipulation that this case would not be brought.
Correct.
So you're all set, and your client, and we'll make sure the dismissal paperwork's entered forthwith, okay?
Thanks, Judge. Have a good day.
All right, thank you, you too. All right. I'm trying to catch up here, but I need a second because I have to get Mr. Gazicki moving. All right, this is 251331 SD, the state of Michigan versus Michael Hinson. Mr. Gazicki?
Who's that on, Your Honor?
Michael Hinson?
I don't have that file.
That's the one you were just talking to me, sir.
That's the impaired Gazicki?
The impaired with a
Hinson,
.0.
is it Hinson? Oh, I couldn't understand. I thought you said Pinkston. Hinson, I did, Your Honor. That's,
Okay.
James Gazicki on behalf of Mr. Hinson, waive reading of the complaint, stand mute. Just for the court's information, this is a case from 2022 that was just recently filed. Also in the file, he was wrongfully charged with a high blood alcohol content. There's somebody else's blood lab report in there. To make this to sum it up, count 1 and 3 are being dismissed. On count 2 is going to be amended from impaired second to impaired first.
Is that correct, counsel?
Correct, Your Honor.
All right, entered a not guilty plea for purposes of arraignment.
Not guilty for purposes of arraignment, Your Honor.
Count 2 is going down to an impaired from an intoxicated. All right, sir, you understand that operating while impaired is still a misdemeanor. It's punishable by up to 93 days in jail, a fine of up to $300 plus court costs and statutory fees, 4 points on your license, and up to 360 hours of community service. Do you understand that, Mr. Hinson?
Yes, Your Honor.
And did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, we did.
Did you understand your rights?
Yes, ma'am.
Did you give Mr. Gazicki permission to sign this form on your behalf?
Yes, I did.
You understand that if you enter a plea of guilty, you'll be waiving the trial rights listed on that form. There will be no trial of any kind.
Yes, I understand.
Okay, and you understand, sir, that if you are currently on probation or parole, I don't know that you are or aren't, but if you are, could be a violation of your conditions if you enter a plea of guilty.
Yes, I understand.
You understand if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation.
Yes.
Sir, knowing all of that, how do you plead to the amended charge for operating while impaired?
Guilty.
Has anyone forced you to get you to plea?
No, ma'am.
Has anyone promised you anything other than the plea agreement to get you to plea?
No, ma'am.
Are you pleading guilty of your own free will?
Yes, I am.
Sir, were you operating a motor vehicle in the city of Taylor back on May 9th of 2022?
Yes, ma'am.
And while you were operating that motor vehicle, was your license suspended? Strike that, I'm sorry. Prior to operating that motor vehicle, sir, did you had something to drink?
Yes, I did.
You recall what you were drinking that night?
I don't recall exactly what I was drinking. No.
All right, was it alcohol?
Yeah. Yes.
Did you drink a lot of it?
I can't remember. I was knocked unconscious after that. That night's a very big blur to me.
Okay.
Make that a no contest plea, Your Honor.
I have no objection.
No objection to a no contest plea. Is there a stipulation I can review the police report to establish a factual basis?
Yes, Your Honor.
I have. Is this a single car accident?
Yes, they were both, charged as co-defendants, but they were both.
Okay. All right, I find that the, police report does establish a factual basis, so I'll accept the no contest plea. Sir, you'll be referred, to the probation department, for a pre-sentence interview. They'll reach out to you within the next 7 to 10 days. If you don't hear them, call the court. Understood?
Yes, ma'am.
All right, sir, you're all set. Thank you.
Thank you
All
very
right.
much.
Thank you. Is this Fowler? Kelly? All right, I've got Kelly at the table.
Fowler?
One second on, Mr. Hinson, you're all set. You can log off. I don't have Fowler in the courtroom. I'm gonna do this one that's in front of me, Mr. Gazicki. This is 251720 FY, the state of Michigan versus Stephen Kelly.
Good morning, Your Honor. Donna Silva on behalf of the people, P 7439.
Good morning, Your Honor. Daniel Eichenberg, Neighborhood Defender Service, P86139 on behalf of Mr. Kelly. And before we address the waiver before Your Honor and bond, would we be able to approach for a minute?
Sure.
Thank you.
I got, you said waiting on Robert? Yeah. So I would say, put the letter. It says in the email. You said they wait, they said they wait. Yeah. Here, bro. Do you need a power cord for that? I plugged it up. Once it went out, and I was like, oh, and I was looking, I hit the power button again. I said, dang, But the thing, normally, I pop up, she will go back. I probably seen it so many times. And when I'm logging, I was logging in, and then it was like. Okay.